muddle into practices that the citizens of the state might not want to, might be inconsistent with what regular Georgians would want. There's a number of issues out there, a number of contexts, a number of media that we're talking about, and generically we're talking about everything from fingerprints to signatures to bodily fluids, blood information, urine samples that speak to drug use and other kinds of things, all the way through DNA, retinal scan information, to tracking of individuals through RFID or other means. These are the whole range of things that would be designated as questions of biological privacy. And we're looking to address them in a holistic way, a way that embraces the harmony of opinions from both sides of issues. It doesn't have a particular philosophical bent, but that looks to, again, as we seek to be as holistic as we can be, looks at context as diverse as educational institutions, what's an appropriate level of information maintained, collected in an educational context, be it K-12, be it Board of Regents, private universities, employment contexts from public employment, private employment, special law enforcement employment. What's an appropriate level of information in a right-to-work state that a private employer can compel an employee to disclose as a condition of employment? That's one of the questions we'll ask in this committee. We'll discuss some today. One of the key environments is a medical environment. What's an appropriate level of biological information in the context of medical care, hospital care, elder care. We look beyond that towards law enforcement. In fact, the August 30th meeting focused primarily on biological privacy questions in a law enforcement context. From when is it appropriate to collect DNA information in the course of an arrest, conviction, and subsequent imprisonment? When is it appropriate to collect fingerprint information? What are the control mechanisms in place to ensure the security of fingerprints? We dealt briefly and discussed the issue of expungement. Once folks are found innocent and information has been collected, what's the appropriate process to deal with that information? Not something this committee can deal with, but something we discussed and recognized needs to deal with as a General Assembly moving forward in other arenas. And looked at, there's some other areas too from the context of public access. Access to sporting events and recreational events. What's an appropriate level of intrusion on one's personal information as a security measure for access to things from the Georgia Dome to Disney World, down to private commerce and banking? What's an appropriate level of security verification for businesses who want to protect the financial transactions, which are terribly important, and balancing that against private security concerns. Those are all things we want to discuss in this committee and make sure we've got the right folks sitting around the table having the conversation, so that as we move forward, if this leads to legislation, which it may or may not, but likely will lead to some action by the General Assembly, that it's done in a way that's has been initiated from the very beginning with a broad vision and looks to see the whole picture and not just pieces of the picture. Because so often, as you've seen, many of you spent years and years down here, when the General Assembly gets to do things, if it's not well informed and all positions haven't been considered and all implications haven't been considered, we sometimes do good things and sometimes do not so good things. So we want to make sure we're looking at this as holistically as we can. So with that, that's really the vision of the committee. Process-wise, again, like I said, August 30 was our hearing that dealt primarily with biological privacy in a law enforcement context. Today is really our biggest, broadest, possibly most significant meeting of this entire study committee, because we're dealing with things, again, as you look at your agenda, varying from real ID to medical context to education to retail and banking to public employment to research and development. So very broad meeting today. I will apologize in advance if we cut folks off and ask them to spend less time on things than they'd like to. But again, in interests of being able to deal with the issues as best we can, we're going to have to, in some cases, limit limit the discussion. So I'd like to welcome Representative Hill. You've missed nothing, Calvin. So
sorry, being late. The traffic was terrible.
You've just missed me talking for 5 minutes, and you've. So that being said, we've got a sign-up sheet for individuals who'd like to speak. We've got a number of people already designated on the agenda. If you're not on the agenda and would like to speak, we'd like to afford you that opportunity during lunch. We've got a lunch break scheduled from 12:30 to 1 o'clock. That's been graciously provided by the Medical Association of Georgia. We'd like to thank you for that. And during that lunch period, we're going to have a candid, kind of open conversation. If there's anybody who's not on the agenda who'd like to speak to the committee, we'd like to give you the opportunity to do that at that time. So that being said, I'd like to call forward Chris Calabrese from the American Civil Liberties Union. Chris has graciously come down from D.C. to speak on the Real ID Act and implications for biological privacy. Chris.
Mr. Chairman, I have written copies of my remarks, if it's okay to share with the committee.
Absolutely.
Thank you. Thank you. Again, my name is Chris Calabrese. I'm the counsel for the ACLU's Technology and Liberty Program. Thank you so much for having me down today. I'd like to take a little of your time to discuss one of the most troubling federal state initiatives that we've seen in recent years, and that would be, of course, the Real ID Act. Let me say up front that the ACLU believes that the entire concept behind the Real ID Act is flawed. Frankly, we think it's a national ID card, and we think that that brings with it all the problems of privacy problems associated with the national ID card. We also think from a practical point of view it is almost completely unworkable, and it will be a nightmare both for you to implement and for the citizens of your state to participate in. Before I talk abstractly or a little abstractly about our problems with the Real ID Act, I just want to let you know sort of concretely what's happened and what I think will give anyone a little bit of pause. Recently, the state of Alabama decided that it was going to begin to attempt to implement the Real ID Act, a small portion of the act. And that was to make sure that the driver's license, the name on every Alabamian's driver's license was the same as the name on their Social Security card. Obviously, in a number of cases, people have gotten married, people prefer to use their middle name. There's plenty of folks whose names don't match up. So Alabama sent letters to approximately 65,000 to 80,000 Alabama citizens, and they started with the folks who had their licenses the longest. So, of course, it was primarily seniors. And they sent them letters saying that they needed to fix their driver's license to make it match up with their Social Security name. And people were, they were terrified, frankly. And it's strange to say that, but, when you evoke Social Security and driver's license, seniors think they're not going to be able to drive and they're not going to get their Social Security checks. And people jammed the DMV. They waited in line for days to get this fixed. One 70-year-old woman finally said on the third day, after she finally got, she'd waited in line for 2 days, she got her license, and then they wanted her to pay the $18 fee to, get a new duplicate license, and in her words, she about hit the roof. This is one small part of Real ID, and I don't think it's a anomalous example of what's going to happen with Real ID. Last year, when state DMV heads were asked for their opinion on Real ID, they described it variously as a nightmare, impossible. There are provisions of the Act that are quite literally, if not impossible, almost inconceivable for DMV heads to implement. And I can talk a little bit about some of those. Before I talk about practical problems, I know this committee is primarily concerned with privacy. So I want to sort of weigh in on that first, and then we can talk, practical stuff a little later on. As I said before, this is a national ID card. There's no, I don't think you could honestly say that it's not. I mean, it's standardized information. The card may look different from state to state. The information will be standardized on it, and probably more importantly, the Real ID Act requires a machine-readable element on the back that is standardized. Whether the Department of Homeland Security has not decided what that element will be yet, but it will likely be a 2D barcode, perhaps a magnetic stripe. And what that will mean is a common machine available throughout the 50 states and certain to be very cheap to provide once it's needed to read licenses across the country, will be able to read the back of the license, collect the information, store it, presumably share it with other machines and databases. So you'll have, with the machine readable element the same, it's effectively a card that will allow you to track people's movements and to know exactly where the holder of that card has been anytime the card has been swiped. Some of the data that's going to be on the card, your name, your digital signature, probably not initially your photograph, but eventually your date of birth, a little physical description, and of course the ubiquitous unique identifying number. And I think it's obvious that we will all have a number when this is all said and done. And it will be unique and it will be on the card.
Mr. Calabrese, if I could, and I don't want to necessarily interrupt your flow.
Of course.
Could you, when you're talking about provisions of Real ID, could you speak to the things, and again, we've brought you down as an expert.
Right,
we want to understand where you think the trends might be going. But I want to make sure the committee understands those things that are enumerated and called for in the Act, and those things that might, at some later date, be brought about by that. So I want to understand that distinction.
All right. Well, the Act absolutely requires, and just to take a step back for a moment, the federal government has not come flat out and required all of these things. What they've said is that citizens of states that do not have Real ID compliant licenses will not be able to get on airplanes or enter federal facilities. So it's it's sort of a sidestep around actual federal preemption of driver's license laws, because this is a pretty big stick. And the Act says that a Real ID compliant license shall have on it all of these standard data elements that are basically exist on a license now, with some exceptions, probably the biggest being their principal place of address. Many states don't actually require your physical address to be on the license. And that, just as an aside, has enormous privacy implications for people like victims of domestic violence, for police officers, for judges, folks who may not want their physical address to be freely bandied about. There's no provision in Real ID to exempt those folks. The Act then requires all of that information to be contained in a machine-readable element on the back, and it requires that all the information in the state's motor vehicle database be shareable with all the other 50 states. So what you have here, of course, is a distributed national database, but essentially one seamless database. From a privacy point of view, those are probably the biggest infrastructure components of the Real ID Act. I'll certain to highlight other pieces as we talk about some of these other things. It's clear that this is going to lead to expanded government use of the license. You already need to show your license to step on a plane. They've talked about it for trains. If this license is freely shareable and savable, what you're going to have is a detailed record of everyone's movements. And, of course, if you need a Real ID to get on a plane or a train, it's going to be a control on your movements. Folks who don't have this license are going to have a difficult time traveling. It's going to be, incidentally, an identity thief's dream. Everyone else's nightmare, but an identity thief's dream. Because this distributed national database will contain in it not only all the information that's on your license now, but a scanned copy of your birth certificate, your social security number.
Mr. Calabrese, you said it will, by the Act, have a scanned copy of the birth certificate?
The Act requires that the information you use to get a Real ID, you'll need 4 pieces of documentation, including a birth certificate or some other proof of your birth date, something that proves that you are in the United States legally or were born here. So typically either a birth certificate or INS documents that show that, and some kind of proof of your physical address, where you're. And all those documents have to be scanned. and saved. So they'll literally be electronically scanned and saved. It'll be part of the database because it'll be part of your driver's license information. Okay. And then
on the specifically, Representative Hill kind of bent over and asked me, specific to this committee, and again, I want to make sure we're laser focused here. In terms of biological information, right. I've heard a lot of banter about in the press, different folks standing up saying we need this, or other folks saying no, we need that. Mm-hmm. Is there anything provided for in the law specifically that calls for a biometric identifier on the ID card?
Thank you, Mr. Chairman. I'm glad you asked that because I've seen that same sort of discussion. And to be very clear, the word biometrics does not appear anywhere in the Real ID Act. Okay. What it does require is a digital signature, or excuse me, a digital photograph and a signature, which are, of course, both biometrics. Okay. And a digital photograph specifically is the biometric most likely to be used, for example, with face recognition. Because if you have to, of course, face recognition requires primarily to work as a biometric that it be taken in very specific conditions. The lighting be the same, there be the same white background. So a digital photograph is specifically, the specific way that it can be used for face recognition software. And the Department of Homeland Security is already considering in its regulation, at least as we hear, requiring the use of face recognition software in order to sort and see if people have multiple licenses. But that is, of course, a biometric. Okay. And I can say with confidence that the Department of Homeland Security believes that they have the authority to require additional biometrics similar to a digital photograph. Perhaps whether they do or not is open to debate. I would suggest that they do. Congress seems to have given them a pretty broad mandate to require what is on the license and what is not. I do not believe, at least as I've heard from DHS, that they will require a fingerprint right now. Okay. Nor do I believe that it will have an RFID chip in the license. However, as you see, current U.S. passports are in the process of being issued with RFID chips in them. And I think that you can view that as I wouldn't call it an experiment since it's a U.S. passport, but it will certainly pave the way for the use of RFID chips in other documents, including, I would assume, probably in the next generation of driver's licenses, because RFIDs will have enormous utility for example, collecting a fingerprint, placing in an RFID chip. You can then, in fact, when you scan the RFID chip, bring the thumbprint up off the RFID chip and use it and compare it in a way that you couldn't now with just having a fingerprint on a license, for example. A human being doesn't do a good job of doing that. Representative.
Question about the photograph and the signature. Mm-hmm. Is that, by the Real ID Act, would that also be required to be saved in the database or scanned or a digital photo and made available to the other 50 states as well?
Yes. The way the Act reads, it requires everything that's in your driver's license database, all driver's license information in the state database. So really, it's actually more expansive than the requirements of the Act itself, because it literally says everything that's in the state database must be shared with other states. So anything that's in your database, and that, I have no idea, and I think most DMV heads would say, are you kidding? That was where we heard that this is impossible line, because of course all 50 states have different IT systems, they have different ways of storing the information, but that's what the Act says on its face, and that's, I would say that was the goal, was to have all this information be integrated and shareable. One thing I haven't touched upon from a privacy point of view is what the private sector is going to do with this information. If you have a standard machine-readable element, it's very likely that when you buy a carton of cigarettes at 7-Eleven, of course they want to see your license to verify your age. It's almost certain that they'll swipe that then, because the technology will be common. So 7-Eleven will be able to buy readers for all of its stores. They'll all be able to read all kinds of licenses, and that information will have a value. It won't, sir.
But what law? I don't see that in the law. think that's a rather broad assumption that 7-Eleven will be able to swipe your card. I think there'd have to be legislation requiring that, and I don't see anything like that in the Real ID Act at this point. So, I'm trying to deal with facts here, not broad futuristic assumptions.
I don't believe this is a futuristic assumption. It's legal now. It is not. It has to be made illegal to protect the information on the back of a license.
It had to be made legislative to require somebody to swipe it, to show it for age ID, but to require somebody to swipe anything now is not required.
Yes,
That's what I'm talking about, the requirement.
You could not mandate, for example, If I said to you, if I was a 7-Eleven employee and I said, I'm sorry, I can't sell you those cigarettes because in order to verify that, this is a real license, it's not fraudulent, I'm going to need to swipe it through my machine. There's nothing that says that 7-Eleven has to sell you cigarettes. And if they want to do that, and I would go even further from what we're hearing from DHS.
Actually, I think the ACLU would back me up if 7-Eleven's tried to stop selling me cigarettes if I walked in with a photo ID. So I really don't. I think we're not dealing with the facts of biological privacy here. I think what we're doing is going off on a big scope on all sorts of other privacy rather than dealing with the concept of this committee, which is biological privacy. And that's what I'm trying to get back to.
Sure, I will be happily leave it, except to say that it looks like in the regulations now, DHS is going to either, I don't know what the regulations look, but they're either going to encourage or mandate the swiping of cards to verify that they're not fraudulent. So, if that happens, I think you will then see private sector piggybacking on that information. But we can leave it aside. It's certainly, we've talked a lot about the privacy of this, the privacy implications. Would the committee like to talk a little bit about cost and practical aspects? I don't want to take from the committee's time except to note one number, $11 billion. That is what the National Conference of State Legislatures and the National Governors Association last week estimated that Real ID would cost nationally.
And again, I appreciate your willingness to share and certainly your knowledge, and there may be some offline questions. I do want to make sure, to Calvin, Representative Hill's point, that this committee stays focused on the biological, the biometric components of this.
Yes.
This is not a Real ID study committee, as it were.
Right.
So,
though I'll do my best to make it one.
So, again, there's nothing, I want to make sure we're clear for the committee, there's nothing provided for in the Act that prescribes, the Act itself does prescribe a digital photograph and digital signature.
That's correct.
Which are biometrics, but it doesn't require for anything beyond that.
Correct.
But other things could be included if the DHS decided they wanted to do that.
That's correct.
So, that's really a policy decision within the department. Okay.
Yes.
In the interest of time, I'd like to ask for a moment if members of the committee would like to ask some questions.
Sure.
I know there's some that have come up.
Okay. That was my wrong question there.
Is there a implementation date that the states have to meet for Real ID Act?
Yes. The implementation date is May of 2008. I would say that date is unrealistic. As you know, DHS has not implemented regulations. We don't expect regulations before the election, and I would be surprised. From what we're hearing inside the department, it could be the end of the year, it could be the beginning of next year. One thing I think I'd like to just sort of note so the committee knows it, one of the things that DHS is considering is actually the creation of some sort of separate entity made up of whether state officials and federal officials, similar to the American Association of Motor Vehicles, but with some sort of quasi-official status that would actually create the technical requirements for Real ID. So it's possible that not only will the requirements be sort of kicked further down the road, if you will, but they'll be sort of put in the hands of this entity that's not at all responsive to state and federal concerns, because it's even one level removed beyond the agency. So that is actually a possibility that they're considering. So, to the long answer to a short question, I think it's very unlikely that May 2008 will be the implementation date. And in fact, we think that there's a number of states that are actively resisting implementing the Act, and it may in fact never be implemented in its current form. And frankly, that's our hope.
I've got one other question, if I may, and it may or may not deal with the Real ID Act. I read a article just this past week in our local newspaper in Cartersville. I think it was an Associated Press article of I believe it was West Virginia. Several counties in West Virginia, the law enforcement has implemented a new program to where the law enforcement agencies are given an electronic fingerprint reader that wireless transmits the fingerprint data when they basically pull over someone to get positive identification of them. There's also a retinal scan that they use to, I'm seeing some nods, apparently I'm not the only one who read it. Is this a precursor to Real ID, or is this something, I'm just assuming you know something about it. But
I wouldn't want to say it's a precursor, because I don't know what they're going to do, but of course, the technology exists when you build the infrastructure. If in the next generation you built infrastructure with an RFID chip in it, it would be logical to include either a fingerprint, some kind of iris scan, or retina, some kind of more advanced biometric to sort of secure the, more closely link the biometric and identity, and then the technology would then exist, obviously, to do that kind of verification on a much broader scale.
Thank you.
What are other states doing? I know we as a state have had some discussion in the last 2-3 years about biometrics on state ID cards. Can you give us a context nationwide, what other states have done? Who would be using biometrics the most significantly, and who would be less so?
It's hard to do. I mean, Georgia was sort of at the forefront in using fingerprints. That's not that common, especially to put them on the license themselves. And then, of course, taking them off the license is again taking I would say a step forward. But New Hampshire is probably one of the biggest examples in terms of their concern over Real ID. For example, they have very strict rules regarding what can be on a license and the privacy of driver's license information, more so than the federal law. In general, it's just they have I think they forbid any collection of biometrics. New Hampshire. And they came very close this spring to opting out of the Real ID Act altogether and saying that they believed it was a national ID card and New Hampshire would not be part of it. The governor endorsed that. It passed the House and fell a couple of votes short in the Senate. Another state that's sort of considering this very actively is New Mexico. I was just out there. They obviously have a very different population than Georgia, but many of their concerns were with not just undocumented immigrants, but also, and I think Georgia will have this issue as well, with legal immigrants, because the Real ID Act creates a lot of burdens if you're a legal immigrant in this country. It requires your driver's license be locked into your date of stay, so many people who are here annually on student visas will have to get a new driver's license every year. In terms of keeping the focus on biological privacy, I'm trying to think if there's any state that's done anything particularly interesting. Some states are using face recognition technology routinely in their licenses. Not too many, I believe. I can find out for the committee later on. I can't remember. But I know at least a couple of states are using face recognition technology routinely, and that's probably the most common biometric screening method that's currently in use.
And when you talk about using the technology, you mean just, or you may not know the answer to this question. They're using the technology to take the photos, so the photos that are on the ID cards are able to be used in a facial ID context. But do you know of any implementation?
And they're routinely using it to make sure, for example, someone's not getting a duplicate license. Okay. They're not getting more than one license. It's typically, as the committee knows, it's much harder to do one-to-many matches of a face. In other words, if I have somebody's face and I want to run it against the whole Georgia database, it's hard to do. You get a lot of sort of false hits. one of the things that, but it can be a useful tool for weeding out duplicate licenses or people who try to get. That's one use. What the State Department, for example, is using face recognition technology for is what they call one-to-one matches. So that if I present my RFID-enabled passport to the customs agent, he is going to, my digital photograph is going to be on the RFID, and they are going to take, as I walk up in the customs line, a picture of me. And then they're going to compare the picture that they just took with the picture that's on the RFID as a one-to-one. And again, I would presume that the customs agent might do a better job of that than a computer. But, we've seen, even in one-to-one matching, fairly high error rates. But they seem to think that this adds a level of additional security. So it's something that they're doing. And again, you see these things federally, and then they tend to trickle down. So it wouldn't surprise me if you started to see it in other contexts.
Super. Appreciate that info.
I mean, the passports are a very, very challenging subject. We're really concerned about the use of RFIDs, and I know this committee has, sort of as part of its mandate, the concern over RFIDs. I won't get into a lot of detail except to say that I think it's almost inevitable that if Real ID comes to pass and that it becomes implemented, you'll see RFIDs eventually in driver's licenses. I'm not going to say that that's anywhere but in my sort of, as a watcher of technology and the way these have been implemented. But it's a technology with enormous utility for these kind of tools, but it also is incredibly privacy invasive in terms of tracking, in terms of leaking private information all over the place. So I just think it's worth keeping in the back of your mind that Real ID and the federalizing of these kind of driver's license standards is likely to lead to some kind of RFID compatibility down the road.
Now, Representative Cooper, go ahead. Chairman. So I'm hearing from you in the context of a license or an ID card, RFID is a media for storing biometric information.
Absolutely, yeah.
Which I think your concern is centered around it being a media can't turn off, can't turn on, can't turn off, that folks, as you're carrying this ID card around with you that has this biometric information in it, it could be reached out and touched by some entity that's not supposed to touch it, is what you're saying.
Yes, and it makes every entity, makes it easier to be touched in general. I mean, if you, for example, wanted a list of everybody who came into this room for this committee hearing, the easiest thing to do if we all were carrying RFID-enabled documents would simply to put a reader right by the door. And then you just collect the information as people walk in the door. They wouldn't even have to swipe their cards. I mean, that's the kind of data collection you could see routinely. So yeah, I mean, it's illicit uses are certainly large. Its legal uses potentially, I think, are very troubling. I think it's a monitoring of people's movements that's not necessary and can inhibit their desire to get together, to protest, to gather with other people who may be, undesirables, go to ACLU meetings, things like that. So yeah, we're troubled by a lot of what we see with RFIDs.
Mr. Chairman.
Chairman Hill.
As I see it, listening to this discussion and many others on RFIDs, and I share everybody's concern about people reaching out and taking your information. It appears that if technology could be improved so that could be turned on and off, if you will, by some manner for the user that only you could turn it on and off. It might require more biometrics. That might require you putting your thumbprint on a certain part of the card before you wanted somebody to use it. But it appears that the way to solve the RFID problem, because it's going to be out there in many other areas, not just this one, is if technology steps up and we find some way to turn that thing on and off. That might be an answer. That might be the real answer to a lot of these privacy questions. So it can only be utilized when the user wants it utilized. So
the concern, I think, and I don't want to take too much of your time on RFIDs, but the way that RFIDs, there are two kinds of RFIDs. There's active and passive. Active RFIDs, you actually use a battery with the chip. Passive RFIDs are literally just a chip. Their power comes from the reader. So when the reader sends a signal, a radio signal, there's enough energy in that radio signal to charge the chip to the point where it can bounce a signal back. It makes it harder to turn them on and off because they're sort of in a dormant state all the time unless someone activates them. The State Department is having problems with its own chips because even if you encrypt them so that the information on them can't necessarily be read, just the simple method, the simple matter of energizing them and having the chip say, no, you can't read it, provides some information. And obviously, the most obvious being, of course, that it's a U.S. chip or it's a U.S. passport that's bouncing the no back. And, just because they can tell because of the signature of the response that it came from, So, it's just they're starting to have real problems in doing that. I think you're right. I think technology often solves these problems, but RFID technology sort of exists to be read. That's the point. So it's hard. You're going very much against the nature of what an RFID is to do this. I'm certainly not going to say it's not possible.
Okay, thank you.
Chairman Cooper.
We talked about New Hampshire wanting to opt out and almost do it. Other than New Hampshire citizens or Georgia citizens being unable to get on a plane or a train, what are the penalties? What are the feds saying?
Well, they would.
Usually it comes with, we won't give you money for something or.
They're saying the other main thing is that you won't be able to access a federal facility, which has in it enormous potential constitutional violations of huge order. For example, if I want to file a federal lawsuit, you're telling me that I can't because I don't have a real ID. If I want to uphold my right to access the federal courts, I can't because I can't actually get into the federal court. These are real constitutional concerns. But the language is actually much broader. It basically says for any purpose that the Secretary shall designate. So the Secretary can say, and I'm not saying that they are, and I think I've seen this, and I think it's a little overblown, but the Secretary, in theory, could say, to cash a Social Security check, you need a real ID. I think what you'll see more likely is probably to open a bank account, because under the Patriot Act, you need a photo ID to open a bank account now, and it just makes sense to see that turn into a real ID, just sort of, you can see that logically progressing. But, and there is there's a 10th Amendment question here that's a little bit beyond the scope of this committee, so I won't take too much time, but there is a 10th Amendment, it's called the Anti-Commandeering Doctrine, which mandates that the federal government cannot commandeer, if you will, state officials to carry out federal policy. It violates the 10th Amendment. There's a real question about whether this Real ID Act either does, or if it's made increasingly coercive, could turn into that kind of commandeering, where a state has no choice but to employ its own DMV workers, its own people, to issue what is essentially a federal identification document.
I have one more question. This really deals with the security. I'm in the IT business, and I work with technology in the military. And our philosophy, a few philosophies, and I still hold to one of those, is if you're storing information electronically, it's not a matter of if it will be compromised, it's more of a matter of when. So I do have grave concerns on the amount of information that we're looking at storing from this and other areas. And it brings to the question, and I've made this statement before, and it's one that I think as a government we really need to implement, is the best way to secure data is to not have it. And so only take exactly what you need, and that way you only have to secure it. With this appears to be a pretty broad scope of information that the federal government would require with the Real ID Act. Does the Act itself prescribe any type of security that has to be implemented, or minimal security standards for all these 50 states that are going to be sharing information back and forth? Does it even address the protection of the data?
It does not. It addresses two types of security, neither of which is the information technology security. The first is it mandates physical security for the licensing facilities, that they be kept secure, which is actually a very real concern. That identity thieves have been targeting DMVs for a long time because of the value of having a license. If you steal the DMV machines, you steal the DMV laminating codes, and you've got yourself a mill to produce licenses. The other security is it mandates background checks for licensing employees. So everyone who actually issues a license will have to do a background check, which of course raises its own privacy and sort of concerns for folks. But it does not actually mandate the protection of the information that's in the database.
In an information system like this, as being in technology yourself, you know that your highest security is the weakest point of that. And my concern would be here is 50 individual entities to where Georgia might be very secure, Mississippi might be very insecure.
Right.
And if we are openly sharing this data, then Georgia's data, even though within our own state is secured, if we're openly sharing with other states, where systems only as secure as the weakest link.
In the written comments, there's a place called the Center for Democracy and Technology did just a press survey of all the break-ins for DMVs over I think it was 2003, and there were 26 major compromises of DMVs in a single year. To the point that they actually had to shut down the Trenton, New Jersey DMV, fire everybody, and reopen it because they, had become so corrupted, and they were selling licenses, and they were, and you're right, you're absolutely right. And you open up, especially to crooked insiders, and there's always going to be, as a license gets more valuable, the price that people are going to pay to attain such a license is going to go up, and the market is going to exist. So, yes, I think that's a major security concern and a major privacy concern, too, frankly, because it's criminals who want this information.
I think from a state level, that's a concern that I would have. I know that we've made a lot of changes in our driver system here, and I think we're going in the right direction, but if this opens our data up nationwide, then that could circumvent all the efforts that we're making to secure our data.
I think that's true.
Thank you.
Any more questions from the committee? Would you care to share any thoughts on kind of a roadmap for protection of that information? Is there a best practices? Do you know of a state that sees and understands the things we've been talking about and has gone to certain levels to protect information? I know, and again, I'll share with you and with the audience. One of the concerns of the committee, and it's outlined in the House Resolution 1558, is that when we've got a credit card number or a Social Security number, those are numbers that can be wiped clean, and I could get a new Social Security number technically. I can technically get a new credit card number, but I can never get issued a new fingerprint.
Right.
I can never get issued a new DNA set. That's an indelible. That's indelible. It's tied to me for the rest of my life. So when this information is compromised, it's a forever thing. It's not a oops, hey, we'll make this okay and wipe it clean and start over. That's the seriousness of this information. And from a standpoint of whether it's on the tort side in states that have penalties for disclosing information or losing control of it, or best practices in terms of technology, could you speak to that a little before we wrap up with you here?
It's hard for me to sort of pick out a state that has a best practices, though I'll try to think as I talk. I think that you're absolutely right that the trivial collection of biometrics is one of the biggest privacy problems we'll have going forward. We were talking before, Representative Loudermilk and I, before the hearing about the collection of fingerprints for, accessing your school lunch. I can think of nothing less necessary to have a fingerprint for and more likely to compromise the information. I think that you need to ask, and I'm just going to sort of put this in terms of principles rather than individual states because I can't think of a particular state that does these things, all of them, but you need to determine what, in fact, you are issuing a license for, first of all. What's the purpose? Is it just to drive? In which case, and I don't think that's the case anywhere anymore, but if it is, ask yourself how necessary is any biometric. Of course, people use them for identity purposes now. Make the collection of the biometric be the least invasive possible. In other words, as sure as you are of the person's identity, that should be the point where you keep, for instance, if you believe that it's necessary to lock down a person's information from their birth certificate, from other pieces of documentation that they have, that may be enough. Because frankly, if I walk in with a driver's license, with a birth certificate that says Christopher Calabrese, and a passport that says Christopher Calabrese, and you then enter that information into the DMV computer, having my thumbprint next to it that says Christopher Calabrese doesn't tell you anything if the documents I've presented to you initially are fraudulent. They don't, all you have now is a fraudulent identity with Christopher Calabrese next to it. So ask yourself, well, is there going to be a need for someone to use this document that they've presented, this driver's license, with a biometric for something later where they're going to collect a biometric? For example, and I think this would be a terrible idea, but just for an example, if it became routine to collect thumbprints when cashing a check, for example. If that's a use that you want to connect the person's identity and when they write a check that they have the same biometric, then, all right, it's at least a legitimate and sensible collection of a biometric for a purpose. If you're not doing that, if it's in fact just sort of an open-ended collection because we might need it later, I guess I would just advise the committee, and I think you all know this, to just think very strongly about not doing that, because it in fact doesn't provide you any additional security, and in fact makes you less secure in terms of your private information and what can be done with it.
I just got to ask you one question. With all of the work that you've done, being an attorney for ACLU and observing what's been happening in our country for the last 10 years and this real ID, do you feel that this moves us closer to what George Orwell warned us of in 1984, that we're moving closer to a police state? Does this take us really further toward that police state that we've been worried about?
I try not to sound as radical as I actually am, Representative. So
just be honest and realistic.
Honestly, I think it does. I think you're creating an infrastructure for control. You're creating an infrastructure to control people's movements. Whether you're controlling them or not, you're creating a physical link between the individual and the information that can be used to track and monitor them. So that's really what a national ID card is. So to the extent that you have that, you can then use it. Whether it will actually be used or not is another question, but in fact the system will be there if it ever is used.
Are there countries that have anything like this or close to this kind of infrastructure?
There are a number of countries, especially in Europe, that have national ID cards. Spain has one. It was very successful in preventing terrorism there. Probably the clearest example is Great Britain, which is probably probably 5 years ahead of us in terms of they just had this debate in terms of they're in the process of creating a national ID card, with massive, wide scale, like even more than the Real ID Act in terms of what they're going to collect in terms of biometrics, where they're going to store it. I mean, they're going to register everybody in something like 5 years, at least in theory. Everybody's going to have to go and get their card, and it's all, of course, how you use it. I'm not going to say that Europe is a police state, because I don't think it is. I'm also not going to say that the national ID card has been useful in preventing terrorism there either. So, you look at it and you look at what you're trying to accomplish and how far down the road, to a privacy violation a national ID card gets, and you balance that.
Calabrese, I'd like to welcome you to stay around as long as you can in case you have something to share with other folks as they testify. I'd like to open up. Is there anyone in the audience who has a short comment, remark to make with respect to Real ID that possibly Mr. Calabrese could speak to, or would like to echo some things he said or that you heard from the committee? Again, we're a little ahead of time, so we'll take 4 or 5 minutes. If anyone from the audience wants to speak to the Real ID issue specifically, just stand up in your place. Mr. Calabrese, if there's no further questions from committee, I'd really like to, on behalf of the committee, thank you for coming down.
Thank you so much for having me. I appreciate you taking the time to consider these issues. As you said at the beginning, the thoughtful consideration of what we're trying to accomplish with biometrics and privacy is extraordinarily useful, and it's not just, I guess, in my work, but I see the misapplication of these technologies all the time. So I thank the committee. Thank you very much.
Thank you very much.
Thank you.
We are running about 15 minutes ahead of schedule, so we will, with that in mind, move forward. I don't think there'll be any objection to that. I'd like to call Mr. Brian Luby and Tracy Field, representing the Medical Association of Georgia and the medical industry.
Mr. Chairman, members of the committee, committee specifically asked that we provide information regarding how the Hipaa overlay applies to these issues, and in that regard, Tracy Field from the law firm Arnold Goldman Gregory is here to address that issue for you.
And Ms. Field, I appreciate you being here. I will say, before we get too far into this, when we're talking about the medical environment, we're looking as a committee not just at medical practice and medical records, but the broader medical field. I know Mr. Nate Gamble's here from Georgia Hospital Association. We think there might be some issues that GHA wants to stay attuned with, and there might be, and even beyond hospitals to senior care facilities and whatnot. So we're not looking in the testimony today to just narrow it down to medical records, but with respect to the primary concern and GHA wanting to kind of get a feel for where the committee's going, that's going to be the scope today. If you'd like to speak at any point later, we'd like to extend that opportunity to you. So.
Thank you. My name is Tracy Field. I'm a partner in the healthcare practice. Is this on?
Yeah.
It is on? Okay, I'm sorry. I'm a partner in the healthcare practice, and actually I'm a geneticist before a lawyer, so, and I did clinical research, so a lot of the sensitivity to the privacy issues, and I worked in hospitals. We represent the Nursing Home Association. I'm not here speaking on their behalf at all, but appreciate the opportunity and certainly willing to answer your questions. I worked with the Medical Association and the Nursing Home Association and a group. I am actually the privacy officer for the health plan in our firm, so the privacy issues are everywhere with us. And I thought I would just say a few words about what Hipaa is, because there's some in the privacy rule, if that's appropriate, and then certainly if you have any questions. And I was trying to listen to be sure to address some of the issues that may be relevant for this committee. In 1996, when the privacy rule was passed as part of the Health Insurance Portability and Accountability Act, the human genome was being mapped, and there was a lot of concern about the protection of information that would become more readily available. So with that in mind, and the insurance industry asking for, we want electronic processing of medical information, we want to do billing, we want to take advantage of the web, we need protections in place, privacy and security measures in place. And having worked in a hospital for several years, you used to be able to walk up, hit a kiosk, and you could pull up every bit of information, every piece of privacy, social security number on anybody in the hospital or anywhere. So this was sort of a long time coming. And what the Hipaa rule does, and there were published comments were 52,000 comments when the rule came out. A federal rule, I guess, if you get 1,000 comments, that's extraordinary. 52,000, you can imagine there was a great deal of concern on many sides. And as originally proposed, the law was only, the regulations were only going to address electronic communication of information, and it's now expanded. The privacy rule covers any information that's conveyed to a healthcare provider who transmits electronic billing information. It also protects information that is gathered by a health plan. It also protects information that is used by a healthcare clearinghouse, which is an entity that takes information from a provider, converts it to an electronic format, and then submits a bill. And so all of that information, upon your entry into, in the typical scenario I use, and I'm going back to the most common page to be sure we're on the same page. I walk into the doctor's office, I give you my name, address, and phone number. It may be in the phone book, but because I hand it to my doctor for my care, it is now all of a sudden protected information. And it is individually identifiable, and it is now called protected health information. And under the law and under the privacy rule, the physician, the hospital, nursing home, any entity that is a healthcare provider that does electronic billing must therefore take measures to protect that data. They cannot use it for unauthorized purposes. That includes training their work staff. That includes sanctioning employees in the event there is a breach. That includes making sure that you monitor the laws as they change, and it also making sure that if there are state laws that are stricter and offer greater protections to the privacy, that you consider how that interacts with the federal laws, because that state law could take the place of the federal protections in that case. So a healthcare provider, an insurance plan, all of those entities are regulated, and they have to be very careful in terms of how that information is protected. Speaking to the biometric issues, if you have your picture taken, and people do sometimes for a lot of purposes in the healthcare, that is protected information under the law. What is not protected is tissue, but the analysis of tissue is protected. So it seems a little odd in that regard, because you can take the information, and there was a great debate about that, and I still get my publications from the genetic societies, and they're sort of appalled at that fact, but it is the law. It doesn't seem that it wouldn't be protected. When one thinks about the privacy rule and its protections, and I'll tell you the security rule also comes into play, and you have to make sure that you are, locking your cabinets. You don't have to hide your computer screen so that no one could possibly see. There are certain provisions that walking into a hospital, walking into a nursing home, you may see some information, but you shouldn't see my medical record lying around on the floor. They want to prevent those kind of gross breaches. The security rule, which has recently been in place, that only covers electronic protected information, and that really is pushing more towards the use of electronic medical records and the ability of providers to use the information. One of the biggest things, there was a concern, you want to be able to share information readily between providers. There is something, everybody probably has seen one of those notices of privacy practices. You walk in, you get it, nobody reads it, and you just sort of say, okay, fine. It's not a consent requirement, but there is a provision that's called an authorization. And in the event you want your information to be released for certain purposes, a physician, a covered entity or health plan has to have an authorization. And how that works is, let's say my health plan, I go and have my eyes tested. It for some reason doesn't pay the bill, and we have somebody in my office who helps with processing those claims. Well, she may pick up the phone and call the insurance company and say, why didn't you pay for Tracy's eye exam? And they'll say, who are you? And I can't talk to you. And who is Tracy? They can't even tell them that I'm a member of the plan. What she should do, and what I would do, is say, you may release to this particular individual this information about me in order to process this claim. And that affords them the ability to release information to the benefits person. She carries out her duties. Hopefully I get my claim paid. And then that information, is available for use. It is no longer protected at that point. Authorizations are used in particular as well for workplace, for drug screening, as a condition of employment. Some people, will have to have drug tests done. There can be uses. There can be entities that do that kind of tests and they get those releases. We, tell people perhaps as additional protections to have those releases are good. There can be also on-site work sites where they do drug testing. That's not considered a HIPAA-covered entity because they don't do electronic billing. So the other instance...
Sorry, I can stop you there. You said it's not a HIPAA-protected entity because they don't do electronic billing?
If they're not a provider doing treatment, right.
What protects information if it's not in a electronic data setting with respect to sharing of information?
Well, what protects it is a provider under Medicare participation requirements. If you have more than 10 employees in your practice, you are required to do electronic billing.
Okay. But if you're a small practice, you don't have 10 employees... then I can't construct an example of that.
No,
but technically there'd be no requirement.
You are not covered under the privacy rule, and what would happen is the state laws that are in place that afford protections, and there are the constitutional provisions in Georgia, for instance, that would protect that information. But you're right.
Okay.
If I did paper billing, and never submitted an electronic claim, but I were a health care provider, I would not be covered by the
But there is
privacy
law
rule.
in Georgia to hang your hat on if you were not electronic billing.
Yeah. The privacy, we've certainly seen a common law right to privacy in your records, and that's basically what people use.
Real quick question while you're on that. How does this authorization affect collection? Is there an issue if you're turning, the medical facility needs to turn over to a collection company? Does the patient sign an authorization as they're being admitted, or how does that work?
Well, that's an interesting question, because what happens is I do a great deal of reimbursement work. I get medical records all the time from my clients, and so I have to write, here, Jane Doe, she had this therapy. I'm what's called a business associate to that covered entity, my hospital, let's say. And by contract, I am agreeing to be bound by several of the provisions. My law firm, we go through training. We have to educate staff. We actually have signs on files that say this is HIPAA, may contain protected information under the privacy rule. We are not subject to enforcement, except we would lose clients in the event we had breaches, and that's typically how the businesses operate. In the notice of privacy practices, there will be, and there's a great deal of consultants, business operations, all of those activities are carried out, billing, collection activities, etc. And those entities, this is how the privacy rule doesn't just affect the providers, but it also reaches out to several other entities, law firms, accountants, consultants, great deal. It also affects clinical research issues in terms of how you can conduct clinical research, how you can conduct research about who your patient population is, how you can serve, who you're serving. There are certain provisions that allow you to do it, but there's at some point, there may be a line at which you have to go, well, wait a minute, now I've crossed into research. I now have to go get an IRB approval, or I have to get a HIPAA release to enable me to use this information for any other purpose.
Thank you.
Is all this information available for subpoena?
Everything for a subpoena. In the event you have a subpoena, there are requirements in the HIPAA rule that talk about required by law, or a subpoena. You certainly have some obligations on the covered entity to investigate the validity of the subpoena. There's some dispute actually going on in the state about plaintiffs' lawyers and between the plaintiffs and the defense bar about even talking to expert witnesses about the care of patients and whether subpoenas are needed to do that, or whether you can even get that through discovery, and that's being litigated right now and being heard in the Court of Appeals. But so the answer is you should be able to subpoenas, a warrant, and in fact this is an area that it does get to be a bit troublesome, and I wanted to raise is in the event I'm in the hospital, I witness a crime on the scene, and I see someone leaving, and let's say they were a patient. If I'm a nurse working there, well, technically the fact that, the criminal is a patient is protected information. There is a narrow exception that enables me to tell law enforcement, so-and-so who is I witnessed the crime on the site, this is a description, and you have certain characteristics that you are allowed to convey. But otherwise, and this happens a great deal, if law enforcement comes into a lot of our facilities and they just want to look through medical records, and they may be saying we're after so-and-so because we think they may have had a certain certain problem. Well, they have to get a warrant, because you can't just come in and take records. And the facilities and the physicians, they face a great deal of, that's a difficult situation to say no, and I've certainly, the Health Fraud Control Unit is quite aware, and we have some struggles sometimes. We'll sit across the table and say, we are protecting patient rights. We are regulated. We have the HIPAA laws. We need to do that. You have to get a warrant. We want to cooperate. No one wants to see those sorts of instances occur, but there's a very narrow exception, and I think there's some law enforcement that's like, we need to be able to get in and get the records and stop it right away, and they do have to go through a process.
So with a warrant, you could have access to really anything that's been collected, tissue, data, whatever, test results. Okay.
There are
Go ahead and answer it.
Well, no, there are exceptions required by law. For instance, there's state reporting requirements, child abuse, birth defects, certain of those instances. Where it's required by law, the entity, can make that exception and do those circumstances and reveal information. For instance, a provider may see someone who has an adverse drug reaction can they make that report to the FDA so the FDA can carry out its public health mission? Yes. But the law says, what HIPAA says is you can only do what's minimally necessary information. In other words, you can't tell them that if I had an adverse drug reaction, well, I also had an appendectomy 10 years ago. You don't just send the entire chart. You only send the information that's relevant to the inquiry.
Ms. Fields, earlier you mentioned that the tissue is not protected, but the information on the analysis, is that specific in the HIPAA law, or is that just it doesn't cover it?
I actually brought you a copy in the preamble. There is discussion about that the tissue is, and of course the preamble is not the law, but it does specify that the tissue is not protected. And there was a great deal of banter about this, certainly in the genetics community. But the analysis is protected. I sat on an IRB for many years, and there were usually when a patient came in and they were enrolled in a research trial, and how that information is released is if I want to be enrolled in a research trial and I want to be treated as part of that, I have to sign a HIPAA authorization to enable that information to be released to the FDA, to the drug sponsor, et cetera. That's really one of the few times that you can require someone to release their information. And it makes sense because they need that information.
So could your name and other information travel with that tissue?
Absolutely.
Wow, that looks like a loophole. Okay, thank you very much.
But there are, other protections, and we work with. It seems as if there's a loophole, but that there are other parameters you certainly don't want. If people protect that information, there are clinical lab regulations in terms of how that information must be protected that are already in place. So it seems like they should have said it was protected, but it's really, it is sort of it's the analysis that is protected, and there are other provisions, and as I say, I tell a lot of people you may not be per se regulated under that law, but there's a standard of care, frankly, that's just sort of raised the bar for everybody in that regard.
Ms. Phil, I don't want to throw you off. If you've got some more information to present, I'd like to go through that. I do have some questions for you that cover some of the things we've addressed.
Go ahead.
You'd mentioned before conditions of employment. Routinely, as a condition of employment, folks provide urine samples for demonstrating drug use or non-drug use. And I assume some places employers would have access to taking blood if they want to look at existing medical conditions. Is that? I guess where I'm going is from profiling drug use, looking at existing or previous medical conditions, and potentially going beyond that to DNA information. Are there any restrictions within Georgia for purposes of private employment, right-to-work context, where there are limitations on information employers can collect on prospective employees' medical history or medical conditions?
I don't pretend to be an employment lawyer, but I would certainly suspect that if they're discriminatory, you can't take my DNA information to decide that I have a condition that you're not going to cover because that's a condition of employment, and I would say that's probably illegal. Again, I'm not an employment lawyer. However, in those instances where you have, and I think drug testing, et cetera, how that would work is if I want the job, and I have to submit to a drug test, then what I do, I sign an authorization, I get the test, and I authorize the entity that did the test, if they're covered under HIPAA, to release the information to the employer.
So under current law or under case law, it's established that employers should have access to drug use information and can have drug-free workplaces, obviously.
That's my understanding, and again, I'm not as savvy on all the employment nuances in whether you have to do it based on suspicion, but I think that's probably the case. You can condition employment on those sorts of tests. Okay.
Similarly, insurance access to medical information. What access do insurance companies have to someone's? I know I just got for myself and my wife a insurance policy about a year ago, and we had to give a sample to demonstrate no drug use, urine sample, and they took blood to look at existing medical conditions. Of course, they had access to our previous medical records. What is the disclosure? What can insurance companies compel folks to provide as a condition of coverage? Do you have any sense of that?
Well, I can tell you, certainly in the HIPAA world, that is life insurance companies, auto insurance companies are not covered entities under the law.
Okay.
Therefore, to release the information to them, what would happen is I decide I want to have life insurance, and as a condition of that, I need HIV testing, drug testing, etc. I would go, and I would also authorize the release of my health information to the life insurance company. The information is protected as long as it was within the provider who gave the care, but as soon as you sign that authorization permitting the information to go to the life insurance company, HIPAA, that no longer regulates how that information is used.
Do you know of any controls within the insurance community that would govern their use of that information that HIPAA wouldn't extend to that?
I'd hate to speculate. Honestly, I don't know. Workers' comp is also not covered under HIPAA. They're out from under it as well. But I don't know. I'm sure they're certainly within the regulatory scheme of the insurance companies, and I apologize. I don't know what the insurance schemes are.
Yeah, we had reached out and would still like to talk to the insurance community on that. Super. Great. Could you speak to that issue at all for us? Just stand up and take. Okay.
I do know that the health information is regulated. If we're talking genetic information, they can't use that. On the life side, is currently not.
I believe there was federal legislation, actually, anti-discrimination on the basis of genetics testing, because there are so many conditions for which you can do screening.
Right.
And I know that there was, but I just don't know the status. I wasn't aware of.
Can you speak to that, Dave? Is it David? Is there legislation restricting insurance coverage using DNA to make determinations for coverage for insurance? Or is there federal law that speaks to that? I don't think Georgia code does.
On the insurance side, there is.
Okay.
On the life insurance side, and there is not. There are no law that speak to that.
I believe that. I think that's my recollection.
Super. Other members of the committee? I do have one more question. Go ahead, Representative Hill.
Just one question overall, because does HIPAA seem to be working pretty well as a concept in keeping information secure? I know it's cumbersome, and any type of security procedure is going to be cumbersome and probably could be improved. But overall, is it doing a good job to do what it was intended to do?
I think there has been there may have been a pendulum swing to overprotect. And the sad thing is, certainly, sharing information between treating providers was never supposed to be impeded under the Hipaa rules. But that has happened to some degree, and you'll have some facilities, providers who say, no, I need an authorization before I'll even share that. And that's truly not supposed to be happening. I think people are certainly much more aware. I know you walk into a doctor's office now, I think they give you. Our favorite story was you don't have to put a bag over your head because people can know you're a patient of Dr. Jones, but they give you now those beepers to call you back in. I mean, I think there's some extremes, but certainly in regard to people are certainly much more sensitive to it. I think the community always had a sensitivity to, we have a lot of valuable information about people, and I know it's certainly being addressed. We're working with the electronic medical records because, you want people to be cared for and have access to information, but a big issue certainly is protecting that information and making sure. And I think providers, and we're doing everything, and I think my sense is there's a lot of screaming, but they're doing even more than they were before.
Thank you very much.
I don't think so. There are, this is a federal statute. There's civil and criminal penalties, and we certainly have seen one thing that has probably been difficult, I would say, for some providers is it's difficult to understand and make sure you're following the preemption issues with the state laws. And because a lot of areas are sort of contemplated within the federal scheme, when you have a state law that comes up that talks about privacy or protection of records, it's nettlesome. And it's very difficult to go through that, and certainly that doesn't mean it shouldn't happen, but that can cause monkeys to be thrown in the wrench, and I think there's some concerns about that.
I do have one last question. It may not be. You may not want to speak to it. One issue that's come up, and I know there's technology that's available that's been brought to light in the last it's becoming more widely known and potentially widely used, is in a medical context tracking devices, both bracelet types that are fixed outside, and then there's also I I think they're referred to subcutaneous chip implants, very chip things. I know that's been used. Folks laud that, hey, they found my puppy dog and brought it back to me. It's been used for cattle and so forth. I know, and particularly since you have some association with the nursing home association, are there any limitations or any legal issues that have arisen with respect to chips and location sensors with people in nursing home context? Have you dealt with that with the nursing homes at all? Or?
Oh, well, I mean, there's a huge problem in a lot of nursing homes with people who wander. And so they use wander guards on their bracelet, to sense if they've gone out of a door. And because it's really for the health protection of the, and the surveyors will come in and cite you if you're not adequately doing that,
Sure.
and if you're monitoring that. Because of that particular issue. I know I follow FDA law as well, and I know that there's some talk about, the chips issue. What I'm certainly personally involved in is this Georgia Health Information Exchange to try to get electronic medical records so that if you happen to have an accident out of state, it doesn't preclude you're getting good care, and errors in transcription in terms of what are your medication allergies, et cetera. That tends to be where people say, and I know that there's a sensitivity to it. I also know that people will call Barnes & Noble and do it on the web and give them their Social Security number or their American Express card at a heartbeat. But I also know that they expect to be cared for, and they expect not to have errors. And the National Institute of Medicine had this study about the transcription errors, and that's one of the reasons that there is a big push for the electronic medical records and the fact that those records should go with you. In sort of a smart card, I mean, we have providers, insurers in the state who are starting to do that and offering that as a service. And I do have some, certainly, I anecdotally hear people say that they're concerned, but they make a choice in terms of, would I rather be sure that my information is with me and that I have a chance to get good health care? Am I willing to make that, as a compromise potentially? And that's sort of what I think we're at the cusp of struggling with right now, and I think more and more people are thinking it's a good thing that you have information. I mean, I can't tell you the number of cases I've worked on where they get they run into problems because you can't read somebody's handwriting, or you can't find the paper chart, or you make a copy and you get denied reimbursement, and then you appeal and they go, well, I couldn't read your records. How can that help you in a
Could you speak to the spectrum of media or that can bring folks electronic medical information from cards to a fixed chip to an implanted chip inside of a person? Could you speak to the range of discussion that's in availability?
I know anecdotally people will now go in, you're going to have knee surgery, and they'll tell them, mark your knee. Before you go under, tell me, you put it on a black magic marker and you mark it so that they know. So that's sort of a less sophisticated. I know that we have, and this is a coalition of the hospital, medical, nursing home, pharmacy association, as well as the plans in the state, and the DCH. We've been talking about this. What are the possibilities? A card for the individual to carry so that they can swipe and use their information. There's been some resistance, but I think that people are now coming around more. Blue Cross just announced that that's what they're doing. Kaiser as well. I mean, I think it's sort of, it's amazing. I'll call a hospital here and I'll say I need an appointment. They go, do you live on Linear Boulevard? Is that still your number? And I'm, oh, okay, yes. And it's great because I don't have to go through it, but it does, it's a little bit startling. I haven't seen as many cards. A couple of years ago, we were getting presenters about the cards, and it was the great Bill Gates mistake with the card. He tried to do a demonstration, and it caught on fire. So he came back 2 years later, and he did the demonstration, and it worked this time. So I think there's been a little more trust that it actually will work. But I don't see the cards as much as I do see more of a willingness, and certainly the interoperability issues between hospitals, nursing homes, and the transfer of information, and the new safe harbor protections that enable. It used to be hospitals couldn't give anything to a physician without risking looking as if you're trying to pay for referrals, and now there's an exception for electronic medical records that wasn't there, and I think there's a recognition of greater need for safety issues. The VA hospital has been held up as a great example of what happens when you are able to share information and care for people nationally. And when I was working, VA hospitals were like the worst place you wanted to go. So there's been a great improvement in that regard, and that's really a lot due to that technology.
Have you seen any arguments made, compelling in your mind, that you certainly you have cards, then you have there's discussion, and I read about it in the literature, I read about it in from op-ed pieces to scholarly journals talking about having people's private medical information implanted in a chip that they carry with them, so if they don't have their wallet with them, don't happen to have their card, they still can, their forearm could be scanned, and yep, we've got all your information here, Mrs. Smith. Have you seen any compelling arguments to a necessity for that, or because clearly that raises some privacy concerns?
The implant, I've seen it more written about and theoretized.
Okay.
In theory, how would this work? Or I know that there is some movement that could be a great thing to have it implanted in you, but I just don't hear people saying, that would be a great thing to do. I think they're more worried about sharing it on the other end more as a passive sort of way.
So from a necessity standpoint, having interoperability and having some means to say, here's my information, and having computer systems talk to each other where they can recognize it and it works, seems to be the real crux, as opposed to it's physically on me attached at all times.
And again, and I'm not a technology expert, but I can tell you what I am told repeatedly is the technology is really not the biggest issue. It's the trust and it's the privacy questions that come up. And that's why the group that we're working with, which does bring all the stakeholders to the table, we're trying to work out a lot of those issues, even just to do a pilot, to have desktop faxing, which isn't even available in every facility, so that you could facilitate a transfer much more readily, not have to go back and forth on the phone 16 times.
Sure.
I think that is a more less obtrusive, perhaps, way that people think that might be you feel like it should be happening, but it's not. And as I understand, the technology is not the issue, but it's really more of these issues in terms of the privacy. There is legislation right now, I know about, because different states have different laws in terms of privacy protections. And if I were hit in California, they may not be able to get records from me from another state if there are different state laws out there, which is typically they have more stringent protections than they do in other states. So that's more. It's more of a cultural issue that seems to be the barrier in my view, anyway.
Super, thank you, Representative Hill.
And Mr. Chairman, I was just going to mention something that actually happened to be part of it today. One of the local hospitals, I requested some records, and they say it takes up to 30 days, and I have an appointment with the doctor in a week that was one of those, and just trying to get those done because they're done physically. They're done with the photocopy machine. And I have over 200 pages of path reports and operative reports. If they could have put that on a little 1 gig, I think it would have been so simple. I could have carried it with me.
Right.
And if they don't have the trust issue to transmit it to another doctor, which is again very capable of doing right now, but at least if they could have put it on a chip, I could have carried it with me. My doctor could have plugged it into his computer and immediately had access to what they need. So I think it's important that we go forward, but with safeguards like that, because for somebody to take 30 days when you need the information for critical information immediately, as you said, you could be in an accident and actually they need it in 5 minutes. Mm-hmm. We have to have some manner to be able to get this important information out, yet still have security safeguards. And I think that's what we're trying to balance here, is looking at that.
And I would the one comment I would say is there's been a great deal of unfunded mandates, and HIPAA was one. Convert to electronic billing, change your codes, and the provider community has borne the brunt of that without any financial support from the feds or the states in that regard. And that is a difficult. So to say, it sounds great, and there are mechanisms now, and in the new safe harbor, a hospital can donate EMR technology to a physician, but there's a copay obligation of that physician. It's the private community that's doing that. So it's great, and I want it as much, but I also recognize, we're cutting Medicare rates. We're doing all of this on one side, but if you want it also does, in the long run, if we think it's going to save lives, which we do, and if we think it's going to save money, well then there needs to be some funding for that. And we have none right now.
Excellent point.
Any other questions from the committee? any questions or relevant points to what Ms. Field has presented from anyone in the audience? And again, I appreciate the gentleman from the Insurance Commissioner's Office speaking up. Well, Ms. Field, I really appreciate your time today.
Thank you.
I know your time is valuable, and we just wanted to make sure we use it well. If there's any other questions or things that come up relevant that your members or clients would like information on or would like to have spoken to or addressed by the committee, we will have one more meeting.
Okay.
So we'll be available to you, and I appreciate your time again.
I'd be happy to help. Thank you very much.
Thank you very much. You guys want to take 10? Tell you what, let's. We're running a little ahead. We've got. Is Dr. Warren here? We might take 10, or might let some other folks.
He's here. He's
Okay.
supposed to testify at the end.
Mr. Craig, are you?
Lunch is almost here.
Okay. We've got Mr. Craig from the Georgia Biomedical Partnership. One of the charters of this committee was to make sure we were speaking to the research and development community and embraced any concerns they had in the scope of the study committee. So again, we welcome Mr. Craig, and again, we've got some time. We would welcome your comments.
Thank you. Turn the mic on there. The top, the little button up.
Make sure it's red up there.
Yeah, red. See the red button on the
Okay. The documents that I'm passing out there include a series of questions and answers referring to medical research, which is where I'm going to focus my remarks on today. So if you have questions beyond that, please don't hesitate to contact me, and we'll get you answers. I don't intend to read the entire document. I'm going to just make some introductory remarks, if that's okay with the committee. And again, I'm focusing my comments on medical research. My name is Charles Craig. I'm president of the Georgia Biomedical Partnership, and thank you for inviting me to this study committee. The Georgia Biomedical Partnership is a private nonprofit association representing 280 pharmaceutical, biotechnology, and medical device companies, universities, research institutes, government groups, and other related businesses organizations in Georgia. We are also the state affiliate for the Biotechnology Industry Organization, which is the national association representing more than 1,100 biotechnology companies, academic institutions, state biotech centers, and related organizations across the U.S. and in 31 nations. The Georgia Biomedical Partnership applauds the chairman and the members of this study committee for their efforts to protect the confidentiality of Georgians' medical information. The members of our organization strongly support the need to protect the confidentiality of all individually identifiable medical information. Our members worked with BIO to help implement passage of the U.S. Health Insurance Portability and Accountability Act. Since implementation of Hipaa, the privacy of medical information and research has not been an issue. Our members, together with BIO, were very engaged in implementation of Hipaa to make sure that genetic information could not be used to discriminate for the purposes of insurance and employment. In addition, our members worked to ensure that the law preserved patient confidentiality while encouraging the continued research and development of new medicines. There also are federal regulations enforced by the National Institutes of Health and U.S. Food and Drug Administration to protect the safety of individuals and confidentiality of information generated about them during medical research studies. Ensuring privacy while encouraging medical research is essential for Georgia's bioscience industry to continue developing new medicines for improving the health of all Georgians and to continue contributing to the growth of the state's economy. I want to give you some background on Georgia's biomedical industry. It's a rich mix of established multinational companies and startup research and development companies. These companies are world leaders in advanced medical research, developing new treatments and diagnostics for heart diseases, cancer, central nervous system disorders, metabolic disorders, mental illnesses, allergic and respiratory disorders, HIV, and other deadly infections. The Georgia Biomedical Partnership will release the first ever Georgia Life Sciences Industry Report next week. This report identifies more than 252 companies in Georgia. They are primarily pharmaceutical, biotechnology, and medical device, medical instruments, diagnostic laboratories, and blood and organ banks. These companies employ nearly 16,000 people. Estimated total product sales in 2006 are $6.2 billion, an 82% increase since 1997. The growth of Georgia's life sciences industry between 2001 and 2005 has outpaced the rest of the state's economy by a wide margin. The increase is significant both in number of companies and the size of employment. The number of life sciences companies increased by an impressive 38.4% compared to a 10.5% average for all the state's industries during that 5-year period from 2001 to 2005. Employment jumped by 11.2% compared to a 1.6% average for all other industry sectors. Between 2001 and 2005, the life sciences industry added jobs in research and development and in manufacturing. Jobs in life sciences R&D increased 46.5%. The overall size of the life sciences industry employment is significantly larger when adding the number of professionals from government research institutes such as U.S. Centers for Disease Control and Prevention, the biological sciences faculty at state universities, and the professionals at the state's research hospitals. In terms of the number of life sciences professionals employed in both private companies and government institutes, Georgia ranks 15th in the nation. Ernst & Young ranks Georgia 7th in the nation in number of biotechnology companies, up from 11th in 2001. The vast majority of these biotechnology companies are research and development stage companies. The Georgia Biomedical Partnership greatly appreciates the opportunity extended by this committee to provide information on legislative initiatives that directly affect our industry. Our organization endorses the BIO's recommendations for state privacy legislation in the attached document that I gave you. However, as I mentioned, we believe that with the passage of Hipaa and the regulations enforced by the NIH and the FDA, the privacy of medical information in clinical research already is protected in Georgia. And I just want to elaborate on this a little bit further. The regulatory system governing medical research in America today is both comprehensive and complex. Biotechnology and pharmaceutical research is closely regulated by the FDA. For both the public and private sectors, strict national institutional guidelines prescribe how medical research shall be conducted. The research process is carefully monitored to ensure strict patient confidentiality. In addition to obtaining FDA or NIH review, clinical trials also must be approved by institutional review boards in compliance with NIH guidelines and FDA regulations to assure patient safety and confidentiality and confidential treatment of data. So I won't read the BIO's recommendations for state privacy legislation, but as I said, there are a series of questions and answers there that may help the committee. And also, if I may, we have the Georgia Biomedical Partnership has its Life Sciences Summit next week, and I would like to invite the members of the committee to be a guest of the summit, and also of a reception the night before, and this would enable you to meet the bioscience community leaders here in Georgia. So just let me know if you'd like to attend.
Where is it?
It's at the Georgia World Congress Center on October 4th, and there's a reception the night before from 6 to 8 p.m. at the Fox Theater. So just let me know if, I believe we did send invitations, but just let me know if you'd like to attend as our guest.
Are there any questions from members of the committee at this point? I've got a couple myself. Chairman Cooper? I did my best to scan through a couple of the items you listed here in your recommendations, and I appreciate you bringing those out. You know, one thing we wanted to do as we kicked this committee off was to have folks advocate positions. What we don't want to have is just folks taking non-committal positions and then we're not really knowing where folks stand. So I appreciate you doing that. I've got a question for you on one of these. It's on page 3. Should privacy legislation address genetic information separately than other medical information? And I confess I've not been able to read that in detail, but I do want to ask you to speak to that issue. One thing we're looking as a committee to address is beyond what I would call pure medical information, which is, you know, in a very, very oversimplified sense, medical history, findings, tests from previous doctor's visits, and so forth, and existing medical conditions which can be spoken to through blood samples and whatnot. Yeah, I do think in the creation of the committee there was a concern that as technology advances, that the power and the great positive potential of DNA information, as that evolves and our ability to understand it improves, that we make sure that it not be used in ways that undermine the issues of privacy, issues of access to care, issues of access to insurance. I don't know if you'd call that medical justice. I don't know what you refer to it as. I do think the committee has contemplated at least considering DNA information for purposes of profiling some future condition as an issue that needs at least careful study and consideration. I do think I think it's certainly worth asking, is a existing medical condition that's been identified by a medical professional in the past, and access of insurance companies, access to employers, access to any number of folks to that information, could conceivably be, I think, and could potentially be looked at as being different than looking at someone's DNA information and see what they have propensities for in the future, not that haven't been recognized to date, but based on someone's inherent genetic makeup, they have a certain propensity to develop in terms of conditions. If the committee were considering or contemplating separating those out and saying genetic DNA information ought to possibly be considered in terms of being protected and limited in terms of who has access to it separately than medical information, would that be in conflict with what you're suggesting, or would that be in step with what you're suggesting?
Well, first let me say that I think that that you're correct about the technology advancing rapidly, and so it's to this committee's credit that it's considering that aspect of things. Mm-hmm. And so the privacy laws should be revisited as this technology advances. I think there's no question about that. But the position here of the Biotechnology Industry Organization and the Georgia Biomedical Partnership is that there really is no difference between genetic information and medical information, and that the genetic information forms a part of the continuum of medical information that is necessary for healthcare professionals to provide comprehensive care across the lifespan of an individual or a family. So I think that one of the revolutionary aspects of the genomics advances is that we are now studying diseases at a molecular level. So therefore that's where disease occurs. Whether or not it's an inherent disease or it's a disease caused by the environment, it still occurs at a genetic level.
Okay.
And the other thing that the scientists have found out, of course, is that your genetic makeup could perhaps make you more susceptible to environmental diseases as well. So I guess the short answer would be that there is no difference between genetic information and medical information.
I guess the crux of the question is, using it for example, and this is something I think everyone in the room would have an opinion on or would have their own unique perspective of, but if, for example, let's take life insurance, for example. Let's say I graduate high school, graduate college, I'm out in my 20s, and decide, I'm trying to get my finances in order, I'm trying to become a responsible adult, I want to get life insurance and think about my young wife, young kids, and think about the future. And as part of that, let's say at some point in the future, part of the procedural check to are you insurable for life insurance is we take your DNA and we analyze it and see if you have any unique conditions that are out of step with the overall population, recognizing that insurance is typically driven by actuarial numbers, and that certain rare conditions, when looked at across a broad population, have very little impact on cost of coverage. But for an individual that was born with a genetic certainty that a certain condition would exist, that typically is a fatal, the kind of thing you can't recover from. Was I, in fact, born uninsurable? Was I born in a condition that I will never receive life insurance because of my genetic makeup? Has nothing to do with the fact of high-risk behaviors. Has nothing to do with not exercising, eating a high-cholesterol diet. Certainly there are certain genetic propensities towards high cholesterol, certain genetic propensities towards heart disease, but is it possible in the future that based on my genetic profile, I was born into this world in an uninsurable condition? And to that point, I think there's some real concerns with respect to looking at genetic information, which portends what can happen in the future, as distinct from medical information, which is something of my medical history. And I ask that question because I do think this committee contemplates that distinction, and I think it's a profound distinction.
And I'm not an insurance expert, so I don't think I can address that aspect of it. And I think that we've stated that we certainly don't think there should be discrimination based on your genetic makeup.
Okay. Yes, ma'am.
I may comment. Women's insurance rates are different than men's.
Mm-hmm.
That's the genetic distinction. That is regardless of whether you have my DNA. And I think it's sort of one of those factors, and I don't know
Sure.
much about the insurance laws, but there are certain boundaries to discrimination that are permissible and non-permissible.
Right.
I do think that the portability requirements under Hipaa were designed to address certain of those concerns that you have, and I can certainly get you information about this genetic discrimination issue. One thing, and I should have raised it before about the tissue question, is blood banks, organ procurement organizations. A lot of these entities have tissue, and a lot of the bioscience industry also uses tissue. The infertility community uses your own tissue to help you, achieve a better outcome with a pregnancy or to achieve a better outcome with cancer therapeutics. So once you start to, if you were to delve into that area, you might be reaching into a hard, vast community, and that was considered certainly under the federal legislations, and there was a conscious decision not to cross into that. I think I should have commented that that's probably really where the distinction between tissue not being protected, because then you're now touching, can you transplant an organ into another person if it's protected information that tissue is there. So it's a perhaps a legal technicality artifact that makes it more complicated, but it does sort of address those concerns.
Okay. Representative Hill.
Yes, thank you very much, Mr. Chairman. And that was kind of my question on tissue, and I think it relates to both of you. And I can definitely see the need for tissue being exempt for, like you said, an organ transplant. Let's make sure we can do it. Again, I would like to, because that tissue out there means your DNA is accessible because it's part of that tissue. And Ms. Fields, you stated there were some very good security concerns outside of Hipaa, and I think at some point I'd like to see if we can find out what those security measures are on tissue, because I think that's a concern, and maybe we don't have them here, but if we could have access to that information.
The FDA regulates tissue, and they are actually actively requiring registration and additional new procedures for that, and there's a more comprehensive plan. There were certain part aspects that were regulated already, and that is expanding, and the tissue community, that is all regulated under and there are protections in place.
Okay, yeah. Sometime maybe we can see if we can access it, Mr. Chairman. I'd be very interested in finding that out. Thank you very much.
Okay, back to what I hear you saying in very simple terms. In 1800s, practically all you could do for a patient was to tell whether they had a fever or that kind of information that you could get from observation and talking to the patient. And that's what you went on. And then we developed blood tests and urine tests and the kind of tests we did. And as medical knowledge has progressed, really using biomedical techniques is just an advancement of how we're learning to treat patients, right?
Yes, I would.
Even though it seems so, but it's just an expansion of our medical knowledge.
Yes.
And it would seem to me that if the committee was going to look at something, that here again it's talking about not regulating the medical aspect, but perhaps regulating how it can be used outside the medical community, like
yes.
an insurance company, like the chairman brought up. So that as we learn more and discover more, that we can use those findings in perhaps treating those genetic factors that you're predisposed for, or helping you avoid the inevitable by new discoveries and so forth. That's correct?
Yes, yes, that's exactly what I'm saying.
One question I had, and we addressed it briefly with Ms. Field, what I believe within the umbrella of your industry is certain medical devices. I don't know if you represent the firm or the kinds of firms that have that create the devices for ID matching. I know my wife just delivered about 2.5 months ago our most recent edition, and we were in Kennestone Hospital, and they, for the first time, which I thought was a kind of a neat tool in the hospital, the baby has a bracelet, mama's got a bracelet. And before mom and baby can be discharged from the hospital, they do a scan to make sure that the bracelet on the baby and the bracelet on the mama matches, so that the right baby goes home with the right mama. And all that jived, and we took the child home, and it's obviously a new bundle of joy for us. So there are identity readers that are used in medical context in a bracelet format. I know there's other contexts where that kind of thing is used. I know there's some concerns and some questions certainly that have been raised to me since we initiated this committee from some members of the public about similar devices that can hold and maintain information that are implanted inside of people, whether it's ingested or it's put under the skin. I think most of the ones I've seen are just under the skin. Is that an industry? Is that a part of your constituency, if you will? And do you care to speak to the medical necessity of various media versus implanted versus attached technology?
As far as I know, our members are not involved in these devices for identity.
Okay.
But the devices that our members are making are for treatment purposes. And I think there's a distinction there.
Okay.
So I really don't think I can address that particular issue.
Well, in the context of in a treatment context, could you speak to certain technologies that are being used and what their uses are?
Well, there are devices that are implantable pumps to release insulin, for example.
Sure.
And there's one of the companies here in Georgia has a pill that you swallow, and it takes a picture of your entire intestinal tract. I'm not a physician, so excuse me. But that's another device that I can think of. And there are devices range from contact lenses to prosthetics, I should say, for replacement legs, artificial legs and things, knees. That's correct, of course. Heart valves. I guess the list goes on and on, but I'm not familiar with any of our companies that address the particular device you're talking about in terms of the identity of the mother and the baby.
It's not just in a mother and baby. It's just, I know there's been, I've read some publications about senior citizens that have chips implanted in them, so that if grandma wanders off from the nursing home, they can scan her. Yep, this is Grandma Smith and this is Grandma Jones over here. That's kind of the technology. Yes, ma'am.
I was actually thinking, again, excuse me, that diabetes, people wear alerts all the time, and they
Correct.
think as a personal choice that they decide I'm going to make that information available because I want to. And I think the implant technology, there are companies that do those implants, and people make that decision because they'd rather have that than risk not having that information available.
Sure.
Just a different.
And I should say, I have read, I don't know if any of our companies are doing it, but I've read about advances in devices where in order for elderly people to stay at home rather than be in a nursing home, there are devices to monitor their systems that could actually then alert the doctor that there's a problem. So.
Yeah. Good. Any other questions for the committee, Chairman?
I just have one, Mr. Chairman. I noticed you mentioned the storage of tissue samples for medical research, and you mentioned the work of the CDC. I wonder why you didn't address stem cell. I know the President has already vetoed the congressional legislation, but you want to talk about stem cell research a little bit?
I guess I didn't address it because I didn't know it was part of this committee's
Well, you
focus.
mentioned tissue samples in your document.
Yes.
It's not
storage.
It's not expressly part of the committee, but if
Do you want to share
there's
your
some
ideas
related
in
issues,
terms
we
of-
can discuss it briefly.
Well, what in particular, I suppose?
Well, just the idea of stem cell research and where we should go as a nation. We know what Congress has done, we know what President Bush's position is, but
as it happens, the Georgia Biomedical Partnership just did a poll of Georgians' opinions on stem cell research, and I can share those with you just briefly. I mean, the poll showed that Georgians, and this was a poll of Georgia registered voters, statewide poll, by a 2-to-1 margin favor or support embryonic stem cell research, and by a double-digit margin, but a little bit narrower than 2-to-1, support therapeutic cloning to create new embryonic stem cells. And another interesting finding from the poll was that Georgians, by a 2-to-1 margin, believe that Georgia should not have any more restrictive laws on stem cell research than the federal government. And then another interesting finding was that by a 75%, Georgians felt that Georgians should have access to therapies derived from embryonic stem cell research outside the state, if it were in other states or nations.
Can you share those?
I certainly can. I'd be happy to give you those results.
I'd like to have
findings.
I'd like to ask clarifying. Chairman Hill, go ahead.
And I'd like to clarify, because I want to make sure that what I've heard is believe what the president vetoed was federal funding for this, which means we'll keep if there is any embryonic cell research, we'll keep the federal government out of our business and let it go on where it should go on. The federal government, as we know, manages to mess up almost everything they touch, it seems like. And if research was to go on and go in the private medical community, where it seems like it should be, and where it can go on probably much better, much faster, with much less burdensome regulations. We've seen what HIPAA's done to slow things down, so it would be within the safeguards, and I think that might actually be, rather than slowing down the research, that might actually accelerate it and make it much better. So I'm kind of pleased we're keeping the federal government out of something for once.
But, Mr. Craig, I appreciate your time very much today. Glad you came early. It's been, I know you weren't dying to stay around until 4:30 to be heard, so you're certainly welcome to stay for lunch and stay with us. If you can add something later in the presentation, please feel free to do that.
All right, and please don't hesitate to contact me if you have follow-up questions.
We'll do that. Thank you, sir, very much.
Don't forget to share that information on the polling. Be great.
I've got 12:10. I'm going to ask my assistant here, are we ready to break for lunch? Or the members committee, do you guys want to do lunch now or just wait till 12:30?
I'd like to run off and come back if you don't mind.
Okay, why don't we take a 10-minute break? Or was it late Friday or I think Friday afternoon we talked, and we're really glad to have him. He's going to come talk about some real scientific insight and experience, some of the DNA questions we had as a group, and it'll just be a resource for us to ask specific questions to kind of separate fact from fiction. That's part of what I've asked him to help us get our hands around. So, Dr. Warren, if you could, I'd appreciate you coming and address the committee.
Thank you, Mr. Chairman. I just have a few introductory remarks. So I'm professor and chairman of human genetics at Emory University School of Medicine. I've been a medical geneticist for 25 years, and I'm currently president of the American Society of Human Genetics, which is the largest professional organization of its kind in the world. So, since the discovery of DNA in 1953 and then the decoding of the genome sequence of humans 50 years later, there's been now, this incredible hope that this insight will change medicine the way we currently do it. The analogy I always like to explain to people is currently physicians operate like firemen. They are called to a problem, they try to put it out. And in the future, we're hoping that physicians will be more like fire wardens, where they're simply watching over everything, educating to prevent disease, and then if something does happen, catch it early enough that it can be alleviated easily. So we can do this because it turns out almost every disease we know of has a genetic component. So there are most common diseases that you all know about have partly genetic components and partly environmental components. And so the idea is if we can identify the variation that we all have, we can determine who might be more predisposed to lung cancer, diabetes, whatever, and conversely, who might not be particularly susceptible. So then people's lifestyles and so forth could be adjusted accordingly to their specific risks. Now, with this kind of knowledge, though, it has raised some concerns in the public, often driven by the media, that such testing could perhaps result in discrimination with employment or insurability, even though there really are very, very few examples of that actually occurring to date. To help alleviate this, the federal government has proposed the Genetic Non-Discrimination Act. This is Senate 307 or H.R. 1227 that passed unanimously in the Senate, now is in the House with 234 sponsors, and hopefully this should pass, if not now, in the next new Congress. But the important thing about this act is that it ensures that an individual's private and personal genetic information cannot be used against them. For example, employers cannot fire someone because they are more likely to develop a genetic disorder than someone else, nor can they require an employee to undergo genetic testing. And under this bill, health insurance companies cannot deny coverage or charge a higher premium to an already healthy individual based solely on this genetic predisposition. And the reason why that's important is because all of these genetic tests never can predict with any certainty whether someone will get a disease. It only comments on a probability. So someone could have a higher risk than the average individual, but no one could say with any certainty they will get sick. And so that is the reason why, in particular, health insurance coverage needs to be protected from this. Interestingly, though, the industry is not particularly interested in this sort of thing. They, and I think it's very telling, and the insurance industry is very good at actuary tables. They're very, very good at probabilities. And this sort of thing is not high up on their radar screen compared to all the other things that people do that vastly increase their risk for problems. So anyway, the hope then is with this legislation, people will not be afraid of genetic testing, and in fact they will go on to realize its potential, reduce disease burden, increase economic productivity, decrease healthcare spending, and provide just generally healthier lifestyles for the citizens. So those are my comments. I'd be glad to answer any questions you might have.
I'll start with the members committee that are here. We've got two key committee members. In fact, Chairman Cooper, who's the chairman of House Health Committee, is not here. She's going to be down as quickly as she can. I certainly want her to have a chance to talk to you. I've got a couple of questions. Representative Loudermilk, Representative.
Go ahead.
Go ahead. I'm still formulating.
Okay. And again, Dr. Warren, I'd like to thank you again for being here. Dr. Warren, I enjoyed about a 20-minute conversation last week on the phone before I was called away for an emergency. Appreciate your patience there. I wanted to get at some of in our conversation, we can share it with the committee. And I believe you said you had testified on Capitol Hill on some of these things. Mm-hmm. So I want to kind of tap into your insight of what the feds are doing. Now, we as a committee want to work in concert with what's happening in the federal government. In some cases, if we need statewide protections, we want to do that. In other cases, if a statewide bill would simply muddy the water, we don't want to do that. Or if we need to be more stringent in certain areas, then we would certainly consider that. You talked about, and I think you, just based on your comments, that the base reason for not wanting to be able to discriminate against someone, if you use that term, for purposes of genetic profiling or by virtue of using DNA information, is because there's no direct causality. There are multiple factors that lead to diabetes, heart disease, and whatnot. I use those as examples. In cases where there is a pretty clear genetic link, and we'd spoken about that, I don't know, some of the conditions that tend to be pretty determinative from a genetic standpoint. Does the federal legislation address those conditions?
Mm-hmm.
Okay.
This is all genetic information.
Okay.
But most of those disorders where there is what we call a single gene disorder, like Huntington's disease, those are extremely rare.
Right.
So, those are not the kind of disorders that really are going to affect large numbers of people. And so I think the legislation, though, while it would cover everything, is really geared towards the common diseases that everybody might encounter.
I know a concern, and we'd voiced it earlier before you were here, was that for those conditions, because they're very rare, they're not, when applied as an impact on a broad population, wouldn't impact the actuarial number significantly. For an individual, if it's got a high morbidity or certainly high medical costs, could have a major impact on them. I just want to get a comfort level and kind of gauge if that stuff would be covered too, because it's not that the legislation we're contemplating would have broad applicability, but it's really more a concern of those few people that it would apply to, making sure they're they're addressed in a way that's consistent with what we'd want. Could you speak to, just to educate the committee and educate the folks that are here, could you give us just some simple numbers we could walk away with in our head? I mean, in terms of correlations, controlling for lifestyle, controlling for other conditions, for things like diabetes, heart disease, other conditions that are studied, what the genetic, I don't know if correlation coefficient's the right term, but what the genetic component of that tends to be. I mean, can you speak to that at all?
Yeah, so the way we think about common diseases now is there's probably going to be maybe 5 or 10 genes, different genes that contribute one's individual risk. And even if you have all of those variant genes that contribute risk, lifestyle and so forth still can contribute a significant amount. But each gene by itself really has very little impact. So we think of things as relative risk. And so that's kind of how many times above the normal population your risk is. So if the average risk of diabetes is 1, having an abnormal gene might give you an abnormal risk of 2. So these are not big effect genes, as we call them, because things like cigarette smoking or things that we know have a much higher impact on health have relative risks of 50 or 60 or higher. So these are individually small risks. That's why individually they can't predict with any certainty whether one will get a disease. Now in the future we hope to identify all the genes that could profile someone's risk, and then combined they might have a relative risk that could be 10, 20-fold. But still the environmental component may be equal to that. So there's still, how, of course, depending on the disease, but, there are lifestyle issues and how one can manage an individual prior to the disease. So there are many drugs you can put somebody on, for example, to manage blood pressure, or they're not sick yet, but if they are going to have a high risk of having hypertension, you can start treating that early before there's any kind of onset of disease. So that's kind of the hope of getting these things understood, is we'll be able to do that.
You're in a field that I feel like is sometimes way over my head. I appreciate speaking to us in layman's terms today, and takes a little bit to formulate some of the questions that I'm going to have. But it's interesting you brought up hypertension. I was recently taking one of those drugs, and my wife mentioned to me, before you were elected, you never had to have this. So I don't know if that's genetic, but being in a high-stress industry and owning my own business and then running for office, I think I was doomed there. When you're speaking of genetics in here, are we speaking DNA, basically? Mm-hmm. Okay. I just want to make sure that the terms that I'm formulating in my mind is what we're talking about. With this DNA, and I hear so much about it, I'm not very knowledgeable other than what I hear in the news, and appreciate the work that you're doing. I think it's very valuable, without a question. But I also hear Orwellian information that we can use with DNA. Can you shed some light on, can, with DNA, without knowing the person, can you look at that and tell details of the person, their size, their weight, their hair color, their eye color? I mean, what can we really derive from this DNA information about an individual?
Yeah, so some of the controversy about DNA forensics revolve around those very issues, and the problem is they're not very accurate. So even though DNA can fairly conclusively identify an individual or exclude an individual by comparing them to, say, a crime scene sample, if you have a crime scene sample alone, predicting something like race can never be better than 50% probability. So it's not very good. And then we know, particularly in this country, where we all are kind of mixtures of different backgrounds, that it's very, very hard to predict that sort of thing. In other parts of the world where people are more homogeneous, you can kind of become a little better in terms of predictions. But in this country, it's not very, very good. So at best, we can do is 50% with perhaps race. Other issues like height, weight, we really can't comment on yet.
Okay. So I'm just trying to determine what's science and what's science fiction. And a lot of times with our media today, it's hard to derive what is pure science. But I appreciate that. And on the research that you're doing, and this is just more for my information, I think, is can you also take, let's say, my DNA sample and look at genetics, and from that can you derive, is my hypertension because my mom might have been prone to it, or is it because of lifestyle? I mean, is that something that you can take from the DNA and basically say, okay, the lung cancer is obviously not prone genetically, it's more than likely lifestyle issue or something like that?
Well, you can't really separate the two, even for lung cancer. So, I mean, I certainly know people who smoke their whole life and are fine. So genetics also can protect as well as make you susceptible. So even with lung cancer, there is a genetic component as to susceptibility. And that's true for hypertension as well. So you never really could kind of separate what is your genetic risks versus your environmental risks. And by the same token, you can take someone who really has very low genetic risk and put them in an incredibly environment that really is prone to bring on those kind of conditions, and they may get them even if they have a pristine genome, which none of us have. So, we can't really do that. What we could do is kind of determine whether or not, you have inherent risk for hypertension that no matter what, you would kind of be the kind of person that one would have to watch to make sure that their blood pressure gets monitored and so forth. Or, maybe you don't have those kind of genetic determinants, and maybe hypertension still occurs because of the job you have and so forth.
Okay. So I'm still safe blaming my health problems on my ancestors.
Absolutely. It goes either way. That works convenient.
Thank you.
One thing that's not been addressed today, but was really addressed in the previous meeting, and you and I spoke about briefly. We talked on our August 30th meeting about DNA's use in law enforcement contexts. And I wanted to ask some questions I'm not sure that the audience and folks speaking last time are really as equipped to speak to as you might be. I know when the GBI crime lab folks came in and they spoke to, we look at a DNA signature and we pull just certain parts of that signature out that don't tie to medical conditions. They're more inert or parts of the code, and they're reduced to a numerical number. I don't have my mind around exactly what's being done there, but when you look at someone's genome, can that be consistently reduced to a number or series of numbers where you could that you could actually have a DNA number as opposed to, or is it something unique that you can have to match physical characteristics, or can you have, does the I guess what I'm getting at is, could you, from a protection of information standpoint, could you get someone's DNA number, scramble it using some code, and then so it's more protected? Or I'm just trying to think through issues of protection of the information. If it can be reduced to a numerical code, could it be scrambled, then better protected? Has that ever been considered? I'm just trying to think of ways of protecting the inherent information.
I mean, the numbers you speak of are really a way of nomenclature for what one sees on a gel by running the DNA out.
Right.
So there's really no way that we currently could envision of altering that in such a way that, we could either change one's profile or hide someone's profile. That's why I think I talked to you on the phone why the O.J. Simpson defense was so brilliant, because they didn't argue the validity of the DNA, they argued the validity of the sample.
Right.
Because, that's what you can argue, is that they didn't collect it or someone planted evidence, but the DNA is pretty much the DNA, and there's really little to argue around that. As far as a number, though, it's not something where you put a sample of blood in a machine and get a number out. I mean, it's really looking at physically aspects of the DNA, and it's just as a way of databasing it easier. They put numbers on it, but the original sample or samples that might be run in the future would always match up.
They would always match. And that was kind of I guess it was kind of inarticulate in the way I asked the question, but I mean, if you look at the different parts of my genome, for example, and I'm a 1, 2, 3, 4, 5, 6, 7, 8, and no matter who looked at it, it's repeatable, that anyone that looked at my DNA sequence would see 1, 2, 3, 4, 5, 6, 7, 8 is Representative Setzler. Just thinking about if that can be reduced to a numerical combination for a person, then that might be more easily protected. And are there ways, from a best practices standpoint, if DNA is being used broadly or being maintained? GBI indicated they only maintain certain parts of folks' sequence in a numerical sequence, that there be certain best practices, mandate, whatever makes sense to protect that. Hey, if you're going to keep this and store it, it shouldn't be stored in the open. It should be stored in a maybe coded way, so it can be decoded, scramble the 1, 2, 3, 4, 5, 6, 7, 8 in a known way, so that anyone hacking into a database and getting access to that would also have to have the code-breaking tool to really know my sequence, as it were. Is that a rational discussion to even talk about?
Well, I mean, I think, having protections against database infiltration is always a good idea, and something like that that may be sensitive or involve legal actions are always, good to have that kind of protection. In reality, though, it would still be hard to kind of alter, other than altering the actual numbers that are in the database, like you could alter someone's name.
Yeah.
But the actual DNA that those numbers describe
is what it is.
You can't change
it.
Really.
Absolutely. I'm just thinking from a security standpoint, as this information becomes more ubiquitous and we have more of it on more people, if we think about, we're going to look at what's really necessary to collect. If we believe this is necessary to collect, then how can we safeguard what we have? Because, again, we spoke before you got here, there's always concerns. Yeah, there's always this supposed hacker that can come in from the outside, but in many cases it's bad actors on the inside that can make that available to people. And because we as a state are in the DNA information storage business, we're there, we're going to continue to be there. I think there are very strong cases we need to be there with respect to convicted felons or incarcerated felons running against previous unsolved crime information. There's an appropriate context for that, but as we store that and as we manage that, what is a best practice for us? And I didn't have any context for thinking that through until you kind of shared that. So,
I might say, the FBI has kind of led the best practice standpoint for forensics. So the regions of the genome that are tested in crime labs are the same exact places in the DNA that the FBI uses and that the military uses. Because these things, besides, criminal cases, are also, very, very good at mass disaster identification. So at the World Trade Center, there was a huge amount of DNA analyses done, and Hurricane Katrina, there was a huge amount of DNA analyses done to try to identify remains.
Sure. If I could, and again, Representative Brooks has joined us. I'll ask one more question, then I'll turn it over to other folks in the committee. In terms of process and technology for analyzing and verifying, I know that's something that we spoke to briefly with the GBI. Could you speak to the emerging technology and ability to rapidly and efficiently look at someone's DNA at a string and say and reduce it to whatever the code is to define the thing to look at a sample from someone? Right now it's a fairly detailed lab process to reduce that to a sequence, numerical sequence. What are the emerging technologies moving forward that could do that more efficiently?
I think the science fiction view of that is trying to get something that could go to a crime scene and actually determine that, and that isn't even close to the drawing boards yet. So everything pretty much is going to be a version of what it currently is. It might be a little faster. Certainly the backlog that crime labs have is not necessarily acceptable, so they could use some help with that aspect. But I mean, it's not going to get down, at least in any obvious fashion in the near future, to a portable device or anything like that.
What is the process now? Can you, in 30 seconds, kind of tell us how they do it?
Yeah, there's a process called polymerase chain reaction that actually its inventor won the Nobel Prize about 10 years ago or so. That's because of its simplicity. It just is a way of amplifying little bits of the genome from very small samples to usable amounts. So that's why they can take a single drop of blood, for example, or a single hair, and generate enough product from that to be able to analyze. Then the regions that are amplified are regions that are, like you said, kind of inert parts of the genome, but they are repetitive, so they stutter. So that means that we vary frequently from one another in these regions. And so the numbers often refer to simply how many of a particular base. So DNA is composed of 4 different bases, A, T, C, and G. There might be 10 T's in a row. I might have 9 T's in a row. You might have 8 T's in a row, and that gives a number. So if they look at a sufficient number of these different places in the genome, they can kind of get then an identity. So in one part of the genome, you and I might have the same number, so that is not informative to distinguish us from one another. But if we look at the entire genome and look at the entire panel, it works quite well. So you can pretty much identify somebody to a probability of one individual versus all of the humans on the planet. So the probability becomes quite strong.
Super. Thank you very much. Members of the committee. Dr. Warren, we had looked at, we had talked before, looking in a number of contexts. I know we've addressed many of those here today. Make sure we can tap into your expertise before you leave. What is the existing research? What's the direction of existing cutting-edge research in the genome? I know we talked about the genome was quote-unquote mapped back in early part of the decade. Where are we now with further fleshing that out, and what does that portend for the next 10, 20 years?
Well, I mean, the hope is that we can take large numbers of individuals. For example, my group, we're looking at schizophrenia right now and taking 500 individuals with schizophrenia and 500 individuals who are free of psychiatric disease and simply comparing their genomes to ask, now, is there a variant that is either more common among the schizophrenics or more common among the normal individuals, to try to identify variation that might predispose towards schizophrenia. The value of that is several-fold. One is that it often gives us a target for a drug. So if it is a particular gene and we know what protein is made one might be able to target a drug to that and come up with an effective therapy. It also could give you a genetic test to run if you suspect someone early on, where sometimes the diagnosis of schizophrenia is difficult. That might contribute to that sort of thing. It could also, people who have relatives with certain diseases then are concerned about their future children and so forth, and they could find out whether they carry such a variant even though they themselves are normal, and if they don't carry it, they have no reason to be concerned about it. So a lot of what genetics does in terms of reproductive health is really to alleviate a lot of concerns. When I started in this business, a lot of people forego having children because they had a relative with a genetic disease, and no one quite knew what the likelihood of they having a child nor how to test for that. Now we can do that. So a lot of times what we do is we can test and tell people they have no greater risk than anybody else in the population. And that's where I think this research is going with a variety of diseases like heart disease, diabetes, and also drug efficacy, drug adverse reactions. So there's a tremendous burden on the healthcare system by people taking drugs that react poorly to that drug. And we don't know why that is, because most of the time the drug works quite well and actually helps people a great deal. But in rare individuals, it can make them quite sick, sometimes sicker than the reason they took the drug. And one of the great pushes now is trying to understand the genetics behind that, because we think that is really a strong genetic component to drug adverse reactions. And if we can understand that, it would be a simple matter of testing someone prior to prescribing the drug and knowing then if that's not the appropriate drug to give them and try an alternative.
We had spoken to the Biomedical partnership right before lunch, and we talked about some things in private business, research-wise, and from an institutional setting in terms of R&D, what controls are in place with personal information? If someone came in, whether it's a student, whether it's an adult from nearby campus that's just a big supporter of your program, and they participate in the study, deliver sample, you take a DNA sample, and whether it's a schizophrenic or whether it's someone in a control population, what's the process of and controls to safeguard that information? And just using Emory as an example.
Sure, we work under Hipaa regulations for that, even if it is volunteer for a study.
Okay.
And they undergo informed consent, and they're explained. They don't have to participate. If they do participate, they can kind of elect to not participate any longer. They're told how their DNA will not be accessible to others in an identifiable fashion, and if there is identifiable information linked to that DNA, how it's safeguarded, who has access, and so forth. So it is not any different really than the medical record.
Okay. So from a standpoint of, it's not, and I don't want to go too much in the weeds, but in terms of it's maintained in some automated database where there's some protection, firewall protections, but not in an offline system in a separate room. Okay, so there's still some concerns in any setting that an outside source would have access to it, but okay. But you all have embraced HIPAA, although you're not, from a statutory standpoint, held to HIPAA. You've embraced it as a framework for.
It turns out it's easier just to go ahead and kind of use that umbrella, because in cases where you're using patients, they of course would be under HIPAA, and then the controls may not. But
sure, rather
than having samples under different guidelines, it's easier to take the most stringent guidelines, and then everybody's under it.
Okay. I assume. I'm not an attorney either, but if. Just trying to think, you all would be subject to, if there was ever a subpoena of information, you would have to, and a warrant. Have you ever heard of any research setting anywhere that was touched by the legal community where they subpoenaed information that was done as part of a study, that information had to be relinquished? Are there concerns there?
I don't know of that ever happening, but it may have. generally, that's not too much of a concern. Oftentimes in these studies, we code everything and then do the study. So really, going back then to the individual is impossible.
I see. So it's not linked back to the individual.
That's generally the way you do it. Other times it is linked, but those are under safeguards. But it is under presumably subpoena action.
Okay. Super. Any other questions of the committee? Dr. Warren, anything else? I'm going to ask if anyone in the audience. Does anyone in the audience have any questions that have arisen from our discussion for Dr. Warren or any members of the committee? Anyone? Just give you a chance to stand up where you are. Hearing none. Dr. Warren, thank you so much for coming today. I appreciate your time. We're a little behind schedule in spite of having started lunch early. That being said, I'd like to call Mr. John Hevner from the Retail Association. He has a presentation for us, and Mr. Hevner, appreciate you being here with us today.
Chairman Setzler, members of the committee, thank you for having us here today. I'm John Hevner. I am the president of the Georgia Retail Association. The doctor's comments may have been just perfect because it may have delayed us our AV needs just right on time. I'll make a qualifying statement first off. I'm not an expert on RFID, and Chairman Setzler, members of the committee, thank you for having us here today. I'm John Hevner. I am the president of the Georgia Retail Association. The doctor's comments may have been just perfect because it may have delayed us our AV needs just right on time. I'll make a qualifying statement first off. I'm not an expert on RFID, and there's a chance today you may ask some questions I may not have answers for today. If you and your staff and I try to capture those questions, I'm sure I can get you answers by your next meeting on 11/29, however. So if we have those numbers or those questions, I would like to answer them for you. First of all, the comments I'm making are also on the handout that I gave you. It's a PowerPoint, and we'll see what we can do. I've got this really nice mouse here. Okay. The Georgia Retail, don't know why I've got that, but how do I use this to go down? Hit the space bar here? Oh, just touch it there? Okay. All right. We do represent an industry in Georgia which is starting to use biometrics, and it's a rather large industry. We have 75,000 retail establishments in the state and more than 715,000 people working in that industry, which represents 1 of 5 working Georgians. Also, the sales to the state were $116 billion in 2005. So we are a major segment of the state's industry, and I think that's a good thing to think of as we go forward. Here's the way retail is growing in Georgia. It continues to grow. A lot of us who have done some economic analysis think retail is what's pulled Georgia out of the doldrums after 9/11, and really has helped Georgia get back on its feet economically through both the sales tax and the income tax paid by employers of retail workers. Here's just some real quick statistics on retail, and we'll move right into the topic matter. 95% of retailers in the state do have just one location. 90% have sales below $2.5 million. 98% have less than 100 workers, and 55% of the retailers in Georgia actually have less than 4 workers. Now, here's why we're involved at all in biometrics. The retail industry has a huge loss of money every year in shrinkage. And shrinkage means loss of goods by many different ways. It means employee theft, it means shoplifting, it means inventory control. But the thing I want to basically draw your attention to here is that 31.7% of retail losses, or $9.7 billion across the country, happens because of shoplifting. And most of the biometrics used in retail are associated with that. Now, as you have heard today, biometrics is an automated method of recognizing a person based upon physiological or behavioral characteristics, and retailers, like I said, have started to use these. The biometric technologies are becoming the foundation of an extensive array of highly secure identification and personal verification solutions. And those personal verification solutions are the part that's valuable to retailers. As the level of security breaches and transaction fraud increases, we feel a real strong need for a secure identification and personal verification technology to be in place in retail establishments that actually have the ability to put them in place. Down one too far. No, biometric solutions provide confidential financial data, and I'll talk a little bit more in detail on that in a few minutes, and also personal data privacy. There's, as you heard today, there's a lot of use of biometrics at the federal level, some use at state level, some use by local level, and a lot in military, and more and more every day now in commercial applications. Now, here's an issue I know you're talking about today, and we have a same concern you have, that trust in electronic transactions is essential for the healthy growth of the economy. I mean, everything we buy today, we buy electronically, whether it's from when you get your credit card approved at the gas station, your purchase approved at the department store, or whether you buy something online, that's all electronic. And we are an electronic age, and honestly, I don't think there's any way we can turn that back. That train has left the station, and we're in that age. Now, alone or integrated with these technologies, some things we're seeing now in biometrics are smart cards, and you probably all have seen or know of a smart card, encryption keys, and digital signatures. And this is going to become a pervasive part of our economy. And for that reason today, we were happy to accept your invitation to come and talk. Now, using biometrics for personal authentication has become both convenient and it actually is more accurate and safer than things such as PINs. Yes.
I'm sorry, Mr. Hebner. Well, I'm not sure I'm clear on smart cards. I might know, but I'm not sure that I do.
Smart card is a card with a chip embedded in it. And the
Okay.
chip would give you some different information. The information may be your account number. It could be more, or it could be more than that. But basically, it would at least be an account number in all cases.
Trying to understand what other things could be in there.
Well, I don't think anyone else in retail is using it now, but it could have any of your personal data. It could have your name, it could have your birth date, it could have your address, it could have anything you have given to the people who use that PIN number.
Bank account.
It could. Yeah, generally it's kept separate from that, but it could. Yeah, in theory it could have that. It could even have a Social Security card number if you gave that to somebody and they were using that technology. I know of no one that's doing that, but it's capable of having that information.
How's that different from a magnetic strip that ties to? I'm not really sure I know what's in a magnetic strip.
And again, I'm not the expert on this, but I think what a magnetic strip holds is much less sophisticated than a chip that's in a smart card. The smart card actually has a chip.
It has a much larger volume of data that can be held in a chip versus a magnetic stripe.
Exactly.
And the accessibility of it, depending on the type of chip, is whether you have to have actual physical contact with the card to read the data. A magnetic stripe, you would have to have physical contact between the reader, the reader and the card. Whereas, depending on the type of smart card, it can be read in proximity.
Yeah.
Like we were talking about earlier, if you had a reader at the door here, it could pick up the identity of those walking in. So,
Yeah.
being in the technology field, I do have some knowledge on some of this.
I am so thankful for that explanation. Thank you so much, Representative Loudermilk. I do appreciate it. Much better than I could have done. Okay, well, biometrics links an object or a person to a specific identity. I'm sure if any of you ever have stood in line at a ATM machine and sort of had somebody standing too close over your shoulder. We've heard of people using binoculars and other devices to steal PIN numbers. People have used electronic devices to steal PIN numbers. Much of biometrics actually can take that risk away, and rather than being a security risk, it's a security enhancement. I hope that's what I can show you today. And the other thing is, I don't know if you've ever forgotten your number. I've had days when I've actually thought of a phone number or a PIN number and to just have blanked for at least a moment, and sometimes longer than a moment. With biometrics, you don't forget your finger or your eye or whatever it is you're using that day to take a measurement of who you are. Now, This is an interesting statistic. 6% of today's companies are using biometrics, and that's not just retailers, that's everybody. So it's really not a pervasive practice yet, but it is growing. And I do think in most of the biometric tools we're going to look at today, that Europe and some of the Asian countries are leading the United States. Their technology's advanced from ours, and we are actually way behind the rest of the world in using biometrics. Now, I want to spend a few times in talking about specific biometric modalities, what's being used, how it's being used, and for the most, to my ability, what we know about the use of that. And like I said, it is limited, so please bear with me, and we'll get through this. Fingerprint. First of all, the fingerprint's probably the most commonly used one right now by people in retail, and it's not being used a lot. It's not being used extensively, but a few people use it. I have a member who owns one single grocery store who does a lot of banking with Hispanics. They actually come to his store to do their check cashing. The fingerprint ID for him is invaluable. It's just a resource he uses to ensure the validity of people who have poor English skills, a poor understanding of our system, and yet still can have safe and secure and reliable ID. So the advantages of fingerprints are, one, subject to have multiple fingers. You can use any one of 10 fingers. It's easy to use with some training, and the training is very, very simple training. Requires very little space. I have a picture in a few minutes of one of the systems they use. It takes very little space in the retailer. Large amounts of existing data allow a background and or watch list checks. And a watch list check is if you have somebody out there conning the system. A watch list check just lists you as a person to be suspicious. It's sort of like, you know, when police pull you over for an infraction along the road, they do a real quick check on you to see if you're a suspicious character. Some of these systems have that kind of safety nets built in, so if somebody has been conning the system or trying to override systems, this helps overcome that. Now, the other thing about fingerprints, they've proven useful for over 100 years. We've been using fingerprints for a long, long time. It's safe. It's reliable. Each fingerprint's unique. None of us, even exact twins, have some dissimilar characteristics in their fingerprints. Now, there are some disadvantages. First of all, a lot of folks don't like to give their fingerprints. I gave a fingerprint many, many years ago when I was in the Army, and I always wonder where that fingerprint is today. It's somewhere out there floating around. And thank God I haven't been fingerprinted since then for anything I've done, so I'm happy about that. There was a job I considered taking where I would have had to have a clearance, where I would have had to give fingerprints up, but had I taken that job, I would have gladly done that. Now, privacy concerns of criminal implications, some people think that if they have their fingerprints put down, it makes them a suspicious character. There's some health concerns by touching a sensor or a pad to record a fingerprint. Some people don't want to have physical contact with something somebody else has touched. A collection of high-quality nail-to-nail images requires training and skill, but current flat reader technology is very robust. And in other words, what we're talking about, the systems that we're using now are ones you actually lay your finger on rather than ones you hold your hand against. There are some out there you actually just put your top of your hand against. I mean, technology is amazing what they've done. And sometimes a person's age or occupation can cause sensors to get an incomplete reading. People who do jobs and use lots of abrasives can actually abrade their fingerprints where they're actually less visible. This is a machine that's being used in Georgia in a few locations today. It's from a company called Biometric Access. The system is one that really is used a lot for, like I say, financial transactions, and what we'll talk about in a few minutes is this has to be a live transaction. I'll get that. The keypad, a person puts their finger there. This machinery also has a small camera at the top, and that is capable of taking a face image at the same time to have a double security system put in place. Like I said, the system is being, to use the system, you first have to fill out an application. In other words, you have to agree to the process. It's nothing that you do randomly. It's a transactional procedure you agree to. The person is asked for an ID, and that ID can vary. It can be a Georgia driver's license, it can be a government-issued ID, or it can be an immigration card. Anything that gives you a reliable ID. Then, after they get the ID, the person puts their right or left index finger in the small part of the reader. The reader captures that fingerprint, and then the retailer scans or checks that fingerprint when a person comes in to cash a check. They check for a signature on the back of the check, and then they would take the fingerprint. A photo, like I said, doesn't have to be taken. Sometimes a photo can't be taken. The retailer that's actually using this system right now is not using photos. He's not capturing photos. It has the capability. He sees no need for it, but it has the capability if he wants to do that. Now, the advantage, this is new. That's the fingerprint. The next...
You have a question?
Sure. Yes.
On this system and the example you had given about the grocer who is using this, what type of responsibility, either legal or other, does he have, or systems in place to protect that data? Because he's actually acquiring some fairly sensitive data and keeping it online.
No, actually, he's not. That's actually said he doesn't have it online. I actually visited the site to make sure that it's a closed system. In other words, the system has no outside access line.
Okay. Well, I mean, online is being stored digitally
It's being
within
stored
system.
digitally in a computer, which is in a secure, locked room in the grocer's building. We'll go into this a little bit later. The question is, can somebody access that? Well, I guess anybody can access anything if they're good enough. The question is the utility of that data. I think I can answer that a little farther on, and if I don't, make sure we come back to it. But if you let me defer that answer a little bit, I'd like to, because there is a technology called liveness, L-I-V-E-N-E-S-S. That's what we'll talk about.
Another question, which you can defer that as well, if it's more or less a follow-on to that, is dealing with retention of that data.
Yep.
Is there any controls in place, either self-imposed or legislative, or anything that says how long will he keep this data acquired on an individual?
And I'm not an attorney, so I'm not sure if I can answer that question completely. I don't think there are any controls externally or legally. I think internally he would have his control would be as long as that's an active part of the system. None of us wants to store anything on our computers that has no utility anymore. If a person's no longer a customer, you're automatically removed. If any of you have got a credit card from one of our retailers and haven't used it in a year, you go back and try to use it, there's a good chance you can't use it anymore. I find that happen to me all the time, and it aggravates me. But things, they don't want to store data on us. Every time there's a cost of storing data, and people don't want data that they're not going to utilize in regular business transactions. In this case, if a person hasn't come in for a year or so and used that system, they're going to be cleaned out of the system because it's just slowing down the system, taking room on the system, and it's not being productive for that retailer's bottom line.
Well, there is a valuable aspect to having data too, and that's being able to provide that information to others, basically marketing that information. And that's, I think, one of the things that we're looking at is if I give some biometric information to the state, we do have some level of control to ensure that that's not going to be given to a third party. I'm not so sure that we have that in place to where if I go to this person's grocery store and I put my fingerprint down, that at some point when he goes out of business and he gives that system to somebody else, that data is still on there, and or his cousin wants to open a grocery store and he offers him a good deal to buy the data he already has, or a third party that just is a marketer of personal information will be able to acquire that. So that's one of the things. Maybe as we discuss further, we can get into some areas. But as we implement these new technologies, these are concerns that I'm having, and I know that others on the committee share as well.
And I know that's why you're here today, actually. Quite frankly, I will say retailers have a wonderful track record, a much better track record, for instance, in the federal government and protecting private information. Much better track record in some of the other major non-retail institutions in protecting private information. I think I won't brag about my industry. We stand head and shoulders above the federal government in protecting private information, for instance. We've done a good job. Retailers are very sensitive to one thing. Customers vote with their feet. If you don't treat a customer right, if he doesn't feel like he can do business with you in a fair and honest manner, he'll go elsewhere. If we don't protect your data, you're going to go elsewhere. Plus, as we know, we're a very litigious society today, and people are going to sue you if I don't protect their information. So we're very sensitive to those issues you're bringing up. And not that we're perfect, but retailers have a really good record of taking care of those kind of things. I think we've done a pretty good job.
Mr. Hebner, if I could, I wanted to follow up. You and I spoke briefly last week as well. Just kind of, I speak personally to most of the folks that are coming to talk to make sure we're calibrated on terms of the topics, and you are spot on with what we wanted you to address. We talked last week about best practices, and it sounds like among your members in Georgia, we've got one grocer doing this, and it seems to sounds like he's made the case that it makes sense for him and his business model. And in a broader, looking nationwide, what are best practices that are there retail chains in other states that have multi-locations that are doing this? And how are they using the technology? Because again, I don't know that the small grocer is going to be the model moving forward with respect to, I collect the information at this ABC retail big box store, and there's 100 outlets elsewhere. It would seem that ABC retail would want to share that among their outlets, so I could sign up at location in Smyrna, Georgia, and then be able to use it down in Bainbridge, Georgia when I'm down there shopping. You'd think. Could you speak to that at all?
Well, I think as a physician who spoke about it, he spoke ahead of me today, said, many of this stuff is in the future. Right now, I don't know of any big boxes at all are using this kind of technology. In fact, I had to dig to find this case because I know you wanted to know what we were doing with it. It's not prevalent amongst retail now to use digital recognition or iris recognition or face recognition, but I'm trying to address that to the extent that we're utilizing it today. Probably some of your later speakers this afternoon in the banking industry and so forth would have much more knowledge about best practices across the country. It's an emerging science for retailers. The thing retailers using most are signature, and we'll talk about signature in a few minutes. They're using signature verification predominantly.
Sure.
Very few are using anything else. Now, do I think they will start using some other things? Yes, and I'll get into that as well. But as far as the digital or iris or facial recognition, I don't think that's even 3 or 4 years coming. I think it's farther in the future than that.
And again, the charter of the study committee, as we've said earlier, and I know you were here from the beginning of the session today, we're looking to not address current issues. We're looking to get ahead of emerging issues to make sure that we're, if retailers have a demonstrable need to use technologies, that there's kind of handrails on that to make sure that we as a state don't fall off the rails and get into, and have retailers that are trying to do their job and trying to prevent theft, customers that are trying to get products at lower prices, faster through the line, all those things which are, I think we all agree, are noteworthy goals. I just think this committee's got some concerns that we get ahead of what current practice is. So I think as we contemplate the future and the shared information that we have, we think hard about the safeguards we'd need to have fingerprints shared from site to site on an online shared network, wide area network kind of thing.
Well, hopefully, as far as retail is concerned, I can assuage some of your immediate concerns and say, it used to be strategic planning was planning 5 years in the future. Now, folks say strategic planning is no good 5 years in the future. Well, I don't think this technology for retailers is even 5 years in the future. I think it's farther in the future. But having said that, we share your concern because we want to do it right. And retailers do want to do things right. They invest a lot of money in systems like this, want them to work well, want them to be secure, and want them to be cost effective. So we share your concern. The iris, the advantage of iris identification, there's no contact required. There's no touching a pad. There's no physical contact at all. It's a protected internal organ. It's less prone to injury, and it's believed to be stable throughout your lifetime. Now, a disadvantage, it's difficult to capture it in some people. They wear contact lenses. It's obscured by eyelashes, eyelids, reflections. Some people, there's a myth out there that if anything shines in your eye, it has the potential of blinding you, and people are afraid of iris identification for that. It can be a myth. The acquisition of an iris image requires more training than a fingerprint. And also, it takes more attentiveness and more skill on the person who's doing that operation. And then there's a lack of existing data that deters the ability to use for background or watch list checks. In other words, as far as we know, there's no list out there captured of irises that say this person's a crook. We don't know that list. And then they also cannot be verified by a human. Somebody can't look in your eye with a naked eye and say, you're who you are. I'm John Hebner and you're Chairman, etc. They can't do that. The face, like I said, I know of no one in Georgia that's using facial recognition. It is a technology that's out there. I think some places in Europe are using this. The advantage is no contact required. It's a commonly used system. It's a camera. There are large amounts of existing images of us out there. I'm not sure how many images of you there are out there, but there are more of me than I would like to think about. And you being elected officials, there's even more of you all over the world and all over the papers and all over the archives. There's photos of us. And it's easy to identify a human, maybe not 100% accurately, but most of us look pretty much like ourselves and not anyone else. Disadvantages. Well, faces can be obscured by hair, glasses, hats, scarves, and so forth. Changes in lighting, expression, and pose. Sometimes my driver's license looks like a completely different person than me. Face can change over time. Aging, scarring, facial hair. Propensity for users to provide poor quality video images. The state loves to capture poor quality images. Just go up your driver's license and see. So that's the disadvantage of facial recognition. A new one's coming out now. I don't know a lot about it, but they're, again, using this overseas, not in America. It's hand geometry, everything from your front of your hand to your back of your hand. Readers are actually reading your hand, not just a fingerprint, but a handprint. And Representative Loudermilk's shaking his head. Yes, he may know more about this than I do, but it is easy to capture.
I think Representative Loudermilk has a letter of Palmer in his district.
Yeah. And this person's actually shown holding medications. There's a reason why I chose that slide, and we'll talk about it in a few minutes. But it's very stable. Your hand changes very little over the years. Disadvantages, it does require training to know how to read a handwrite. And it's not a palm reader, it's electronic. Some hands are not sufficiently distinctive for large databases. And then to capture all the data from a hand takes an immense database. It's not just as simple as a finger or a name or an address. It's a huge thing. Voice recognition. I know of no one in retail that's using voice recognition. Some research facilities use voice recognition. It's out there. It's fairly well accepted. There's no contact. And the technology exists readily. The disadvantages, difficult to control the sensor, and sometimes the wavelength that the voice is on can impact the recording from one place to another. And then, again, a lot of voices sound somewhat alike. Unless you have high technology, it's not the best system in use. This is the most common one. I'm sure you've all used one in the last month. If you used a credit card in the last month, there's a good chance you signed a pad just like this. And this is the ubiquitous form in Georgia of biometric information capturing. This takes you do put your you put your name in there. Your name is captured. Your name's put into a system. It's not put into a system for any kind of a verification, which I thought it would be when I started researching this for the chairman. It's used only in there as a affirmation of contractual responsibility. In other words, they don't. When I go into Home Depot and write my name today, when I buy two gallons of paint, and go back Friday and use the same card and buy 4 2x4s and sign my name left-handed, the machine's not going to know it's not me. In other words, it doesn't contain that data. All it does is contains it for it doesn't compare it. All it does is contains that to a record, a proof of purchase. So it's not sensitive or it's not easily accessible or usable by anybody who wants to put that system. Now,
it isn't connected to the credit card company to verify the credit limit or allow that purchase or not?
The credit card company does not verify the signature. They verify the transaction.
Okay, they still verify the transaction.
Yeah. In other words, the signature...
And the signature is on file in case there's a...
But the personal identity of the signature isn't an issue. It doesn't match Calvin Hill this week with Calvin Hill last week. It makes sure you are pulling that card and if there's a signature. In other words, there's not a verification process in the computer in the store or at a remote location that says these two signatures match. That doesn't happen.
Does it stay on storage in case there's a problem with that transaction that needs to be compared at a later date?
Well, it's in there, and it could be pulled up, but again, it could be a stolen credit card.
Yeah, at that time it could be brought up and
then it would be brought
compared.
up and not matched, but there's no use of that to verify it pre-purchase.
Okay.
In other words, it's not a qualifier for the purchase. If that makes sense. It doesn't.
It does, but it retains it.
Again, I think if you've been to Europe, you know that people in Europe are buying everything from sodas to clothing from machines using cell phones. Hasn't hit the United States yet. Some companies in New England are now starting this. I think within 3 to 5 years we'll see this in Georgia. So I think this is a technology is coming. Consumers are turning more and more to cell phones as information gathering tools with which they can get the latest sports scores, weathers, music, and videos. But it's not surprising to anybody now that they're using this technology to develop other ways of operating. And for us, the cell phones will become legally an extended peripheral of nobody in Georgia. But in Michigan, we have a gas retailer who actually is sending out via email every time gas prices go up. Anybody who's given him their number, he sends a text message out to them. And then, after they get that message, the consumer has 2 hours to get to that gas station to buy gas. So you're saying, what's the significance of this? The significance of this isn't in Michigan that they were trying to deal with this high gas price thing you dumped over the summer. Significance is we have a retailer who's communicating with people about items on sale via the phone. This is going to be the technology of the future, I think. And whether you like it or not, it's coming on. That's something we can deal with in a positive way. Now, just by using that phone, they can, and by permitting in advance, you have to sign up for this. It's nothing that you do, you're subjected to unless you are agreeing to this process. You can actually register to allow the store to send you messages, to authorize payment even before you get to the store. Hey, I'm coming to the grocery store, I'm coming to Home Depot, I want to authorize a purchase before I get there, right? That's your information in the computer, you walk in, show them your phone number actually connects, telephonically with the system there, it's paid for, gone. It's happening in Michigan now, and we think there's a good chance it's going to happen elsewhere, and probably eventually here in Georgia. So there's not even need to check out. You just walk by your car, park your phone, would send a message to the system there, and the sale would be completed. Now, we see it being used for things like sending you coupons. I'm not sure if you get email. Everybody gets email today. There's a day goes by that I don't get a coupon from somebody electronically. One of my good members, Best Buy, sends me coupons regularly, and I love them. And others send me coupons as well. So you're going to be getting coupons. You're going to shoot out messages to you about special sales, special promotions. It's going to be a way of communicating directly with the customers. The integrated systems will identify shoppers via their phone number and will automatically enable the merchant to offer items that are especially for them. So if you go to Kroger now, as I do, I'm a Kroger shopper. I have a Kroger Plus card, and Kroger, and I use it because I save money. But part of that deal was they know everything I eat, everything I drink, everything I use in my household that I buy from Kroger. They have a record of. I'm not worried about that. I'm willing to make the trade-off, the savings I get. Other stores in Georgia are doing the same thing. The same thing is going to happen with phones. If you agree to have your phone be part of the system, it's going to give you a financial benefit in return.
Mr. Hefner, again, to these points, I just wanted to allay any concerns you may have. I mean, this committee is not principally concerned with emerging technology. This is not an emerging technology. Let's roll back. Let's go back to 1975 business practices. That's not the name of our committee at all. I mean, I think this. I'm speaking for myself here. I think the cell phone things you describe are exciting advances. I think the concern of the committee, just to reiterate, is the indelible, unchangeable nature of person's biometric information. I can never change my fingerprint. I can never change my iris. And if that information is made available to bad actors, that's, I think, the primary concern. Not that we have any concerns with it. And I know you've got, you're a strong advocate for the retail industry, and have some concerns when folks have concerns about potential uses and retail applications of technology. I wanted to say again, there's, I think I can speak for the members of the committee, that our chief concern is not emerging commercial practices. Like they know that Kroger knows that my wife orders, buys 90 diapers a week. That's fine for them. I think it's the issue of that indelible information that if it's compromised can never be changed. I can always change my cell phone number. I can replace my Kroger Plus card. I cannot change my fingerprint.
Right, and I'm most to your point. Two more slides will be your point.
Yes, sir.
I will say it's all about extending convenience to our customers. People use systems to make their lives easier. Now they no longer are tied to their computers, but they'll have their phone or other device to help them be more efficient shopping. Now, the question we're getting to today, I think this is the bottom line for all of us, are biometrics safe to use? So first of all, biometrics are typically passive and just designed to be physically safe. I know it's not physical safety you're talking about, it's personal identity safety. It's only there too. biometric systems usually implement ordinary computing and technology, such as you have every day. We're on camera today, we're being recorded today. You had to go through a security system to get in here today. I had to show a photo ID to get in here today. So it's things I'm living with today. It's nothing new. Now, most of the systems out there use technology we're familiar with: digital camera, sensors, and fingerprint sensing. Fingerprint sensing is roughly the same touching a doorknob. Now, can anybody steal my biometrics? Now, this is a question you're worried about. It's possible to steal biometric information in certain modalities. For instance, this actually happened, I guess, one time. Somebody cut off somebody's finger and actually tried to use it to access a fingerprint system. I guess it's possible to do that. It's probably possible to create a synthetic iris, but it's not practical or realistic in most situations. We'll get there in a minute. This is why vendors are working on liveness detection. In other words, technology is not working. In other words, I cannot come in with a fake finger and put a fingerprint down to cash a check. I cannot come in with a fake iris and hold it up in a retail situation. Now, you see these Mission Impossible type movies in a secure room where nobody's watching. You can put a fake handprint up there or a fake eyeball up there and you walk in. Retail is live, person to person still. I don't see that changing. There's always going to be some personal eye-to-eye contact. And for that reason, if I have your fingerprint, if I have your iris print, if I have your retinal print, it's not going to do me much good in a retail situation because people are going to verify that I'm not holding somebody's eyeball in my fingers. I'm not holding somebody's finger in my hand. That sounds facetious, but I'm being quite sincere. It's hard to create fraud using this technology and everything else. Now, why do we want to use biometrics? Because they are unique. They pass on identification. That's an intrinsic part of you. That's the part you're worried about, Sharon. There's also the part that makes us valuable. The people think that smart cards, magnetic stripe cards, physical keys, and so forth are a lot safer than things like passwords and PIN numbers and so forth. And we think it's a much more secure way to do business. I have had a wallet lost in my lifetime. If you've ever had a wallet lost or stolen, it's quite a experience, not a good one. I'm more worried about losing my wallet than about taking my fingerprint, quite frankly. And I'm not trying to be naive about that. I really am. Now, we do think that it's much more secure than passwords, and unless you're truly a scientific evil genius, you're not going to be able to take this information and use it to any advantage in a retail setting. You just aren't. You're not going to crash anybody's system and steal lots of merchandise using a fingerprint taken off of some kind of electronic media, because you're going to present yourself to use that technology. That liveness is the issue in retail. I don't want to go in there. I want to go really quick. This here, liveness detection is yours to ensure that only characteristics from a living human being can be enrolled, stored, and recognized in a biometric system. Liveness detection can be used to recognize spoof attacks, in other words, submission of false biometric information. Now, I think I was asked originally by Jennifer to talk a little bit about RFID, and I want to talk about RFID, but first of all, I want to say real quickly, RFID is not biometrics. It's a technology you're concerned with, but in no way is it biometrics. Unlike biometrics, RFID systems are not biologically linked to an individual. RFID is a technology that stores and retrieves data remotely through devices called RFID tags or transporters. So it has no personal information at all. RFID tags, and I've actually used and seen the equipment, actually use radio frequency to exchange information. An RFID tag, as said earlier today by, I think maybe the gentleman from the ACLU, thank you, talked about they have a small antenna in them, and they do. The antenna has a electronic connection, either passive or active. Passive, there's no battery in the RFID, and most of them are passive. Some RFIDs are capable of having a battery or energy source inside. They're used right now. How many of you live up 400? If you do, the ePass tool is an RFID technology. Building access cards, RFID technology. Parking garage cards, today a lot of them are RFID technology. And RFID technology is starting to become into the retail world because of Walmart. Walmart's the one that said, we want to cut losses, we want to increase efficiencies, we want to use RFID as an inventory control mechanism. That's what it's for. Not a customer measurement mechanism, but inventory control mechanism. And unfortunately, what we've seen so far from the rest of the retailers, even Walmart suppliers, is a pushback on this because of the costs. Profits in retail are small. The average profit for a retail grocer is about $1.50 to 2 pennies on a dollar. RFID tags cost anywhere from 2 to 15 cents still. And right now, RFID tag cost is a real issue for us and anybody who wants to use the technology. I do think, however, and I think anybody in retail would tell you that RFID will replace barcodes, and also they'll probably replace credit cards, because it's a technology that's really in the future. Now, not the same technology. The two won't be linked, but you're going to be using more sophisticated credit cards, more sophisticated product identification codes in the future. Now, RFID tags have the potential to make it exceptionally easy for companies to track inventory. And this is the real attractiveness. For instance, I'll tell you now, if an RFID tag is put on that where a shirt is manufactured, when that shirt leaves that factory as part of a caseload of shirts, it's recorded, or can be recorded. When Walmart gets that shirt into their distribution center, it'll be recorded. When that shirt leaves the distribution center for a Walmart truck, it'll be recorded. When the shirt goes into the rear of a Walmart store, it'll be recorded. When that shirt comes from the storage in the back of the Walmart store to the Walmart floor, it'll be recorded. When it goes through the sale process, we re-record it, and that's where it stops. No one's using that technology beyond the cash register today. In fact, the technology today won't even measure it within a couple feet. I mean, just beyond a couple feet. It isn't something that will measure at 100 yards or 50 yards or even 10 yards. It's a short distance identification process. Yes.
Mr. Evans, could you just fill me in? I'm not sure I really know the details of what you're talking about. Are we talking about a tag on a shirt, or are we talking about something implanted within the shirt?
It could be either. Chips sometimes are implanted in things. Like right now, chips are mostly implanted in boxes of goods. In other words, if I have a box of 12 cartons of Tide to come through, each bottle of Tide doesn't have a chip. The carton does. So it's both. For the most part, chips are being used today on carton-sized goods, on multiple packed goods. It isn't being used today on like the tie I bought, or the pair of socks I bought, or the shoe I bought. Having said that, it's capable of being used there. It's capable of actually being attached to those because they're so small.
Is there any, on the retail side, on this retail sales inventory management side, is there any reason that the necktie that I buy, which comes with a little white tag and a little plastic strip that holds the tag to the tie, is there any reason that the RFID or the RF tag couldn't be on the RF transponder, or the passive chip couldn't be on the tag instead of embedded in the product itself in a way that can't be removed?
Well, I think the issue for that is that it can't be removed is the whole issue. There's all kinds of retail fraud where people change tags. There are people called boosters, and I don't want to talk about too much. People who actually go into stores, steal large quantities of merchandise, change the tags themselves, and bring them back for refunds of things they were stolen. It's a billion-dollar industry in the United States, largely financed by organized crime, and with money being funneled out of the United States into terrorist countries. It's proven. Having said that, I don't want to ring those those bells, but having said that, there are reasons for embedding it in the product. And basically, that's for the security of the system.
Is there?
Where you will find these embedded in the product, I found one recently, is a lot of times in electronics, you will find electronic media, CDs, software. A lot of times the tag is inside the box. Recently, I can't remember what electronic device it was that I purchased, but being a tinker, I took the back off and I found the tag inside. I think it was a DVD player that you hook to your television. The RFID chip was actually on the inside of the case that most people wouldn't take off. So there are cases that might not be woven into the fabric of your tie, but in higher dollar items, a lot of times maybe on the inside of your television, the RFID chip is implanted inside the case, to where unless you took the case off, you wouldn't see it.
And there's a good case that wasn't actually RFID. There's a good case that was just an alarm tag, that if it leaves the showroom floor without being paid for, it goes off.
Okay, Phil?
And, I think we digress. We're now talking into, and unless it's tied into biometrics here, and again, it's easy to go astray in this field because RFID tags, as you said, are not inherently tied into biometrics unless they're a type of tag. For some reason, somebody has input biometrics into it. So I think on retail purchases like this type of thing is really not applicable to this committee, if I may. And I know I'm going to have to leave very early, and I'm going to apologize to some of the other people. So I'd like to perhaps see if we can get it a tad back, more on focus. Not very interesting discussion, but I don't think it's totally, this part of it totally applicable for this committee. And unless we're working on a type, as I mentioned, on an identification card where you had biometrics, your biometrics tied into the tag itself.
And Representative Hill, the only reason, and I thank you for your point, and I appreciate that. It's one of the things we said earlier in the committee meeting. I think the only reason I'm exploring it, and we might better do it offline, is the idea that products that people carry on their persons that have passive RFIDs in them, I know there's plans, ideas, fantastic though they may be in some people's minds, that if you have RFID in clothes and items that folks carry with them, folks are carrying a digital signature that they're not aware of themselves, that they walk past a shelf and Ed Setzler or they can track to a product number and a unique 38-digit unique identifier for the sport coat that I bought. Walked and looked at some high-priced perfume, so we're going to send them high-priced perfume coupons or advertisements. I know it sounds fantastic, but in effect what we're doing is having passive RFIDs that are on people's persons, unbeknownst to them, that they end up carrying around with them through their lives, and it becomes not an issue of an indelible biometric, but a personal tracking means and a means of watching. It's just an issue of personal information and whereabouts and being secured in one's personal effects.
Wearable biometric.
So I think that's the issue, and we can move on.
Yeah, no, it's up. I have as much or little of this as you want, and so I did it because you've asked me to. Basically, I think you're on target there. That's the biggest concern. The biggest concern is not in the stores, and quite frankly, technology doesn't exist right now to go ride by your house and tell you and give us an inventory of what you've bought because of RFID tag. Nor does the technology exist. I think it will be here eventually. As you walk through the store, they'll say, "Oh, Ed Setzler, good to see you again. We have your Post Toasties on sale today on aisle 4 because I know you eat Post Toasties." That's coming. Having said that, it's not here yet, but we're a long ways away from that.
Oh, right.
But let me just make a few comments, and we'll kind of sum up and see if you have any more questions. First of all, I have done at the bottom of my presentation a couple I want to just share with you, and we're almost there. Actually, I want to go. I wanted to go up. I missed one. The comment I wanted to make was, first of all, do biometrics invade a person's civil liberties and privacy? And this is a good question because of the first presenter we had today. And many U.S. Supreme Court decisions, including, I have a list of them in my presentation today, have affirmed that biometrics do not invade an individual's civil liberties or privacy per se as they exist today. So I cautiously urge you to move forward on this, looking at both the legal ramifications, the business ramifications, to make sure any decisions you to make or legislation you'd sponsor is the right decision. I think what we look at as retailers is very few retail businesses now are exclusively within one state. So when you look at legislation here in Georgia, please consider how you do meld with the rest of the country. It's almost impossible to do retail business today and have it be contained in any geographic area. We're the world leader in innovation, and the technology we use must also mesh with the world, not just with Georgia and South Carolina or Georgia and Tennessee, or in case of Walmart, Georgia and Arkansas, but it must also mesh with Georgia and Europe and Georgia with Asia. So be careful what we do. Customers, as I said earlier, if we don't treat customers right, if they feel we're abusing their privacy, if they feel we're abusing their security, they will not shop at our member stores. They'll go to a store where they are treated well. And lastly, that little EPC code, that thing that's on RFID, does not track personal information. And right now, Chairman Setzler, the technology even to track you doesn't exist. I'm not saying it can. I'm saying it's probably out there, on somebody's research shelf now, but it doesn't exist. And again, all this technology is too expensive to put out broadly in today's retail market. I thank you for the opportunity to talk with you today. I've actually enjoyed it. I hope it's been somewhat helpful. If there's other questions you have before your last meeting or before session or during session, we'll try to help you.
Other questions come in?
Just to follow up that, I've been following my information correctly in some of the discussions to alleviate the chairman's concern. There's discussion that RFID tag, if it was to go out the store, would also be used as an alarm tag, could be used as an alarm tag. Therefore, unless it's been burned off, and you can burn it off, you can destroy that chip electronically at the cash register. So if it was to leave embedded, hidden in that tie, it would theoretically set off the alarm at the door just like a regular alarm chip does now. You'd have to return and burn it off. And that is one of the safeguards that's being looked at electronically in those chips to protect people now. So that's a very good question. I know it's being looked at, according to some of the retail mags that I've been reading, as a futuristic thing to protect the consumers, just like you're concerned about. So theoretically, there's no way to walk out of that store with an active RFID tag embedded in your clothing without setting off an alarm.
I think what could happen would be that a particular unique ID, a 38-digit alphanumeric code, when it's scanned at the cash register and paid for, then that numeric code goes to the system and says, this one can pass through the door because this one's been cleared, but all others that have not been cleared can't go out the door. So that you're able to clear unique item by unique item, so that you don't have to disable that actual RFID.
Yeah, but you can disable and you can burn it off. So there's a lot of options there. It depends upon how it's approached.
And sometimes that's the case. I think sometimes that's not the case. It's just a matter of what the technology that retail outlet uses, and that's just a point of discussion. That if they could all be disabled, I don't think there's an issue. There may not be an issue as it is, but I think there are technological provisions for a specific item, this specific sport coat, not this sport coat, to have been checked out and get out the door without alerting. So that's
both of you are actually right.
Yeah, it depends upon what the retailer chooses to use.
Yeah.
I do have a quick comment. Just something that Representative Hill was saying is one area we tend to not look at is we tend to look at RFID as a transmitter only. Those can be programmed. So there is the technology. It might not be what's being implemented now, but in the RFID technology, there is the capability of linking your purchase information into that chip. So I think that's for some of the concern Representative Setzler has. But Mike, I have a comment and a couple of questions. One, the slide dealing with do biometrics invade an individual's civil liberties and privacy, being no, I think might need a little more discussion there. I think that statement is like saying, does an automobile violate the law? No, not in itself, but it has the use of it can violate the law. I think the improper use of biometric information very well can and does violate civil liberties. So the fact that we have biometrics or we use them doesn't necessarily violate civil liberties, but there is the potential for the misuse of those, and that's where really my concern comes in. Even in the retail industry, and let me give you a scenario that happened to me that would illustrate where my concerns come from. Not too long ago, I decided to get a P.O. box and another phone number in my house. And I decided this was a good time to do a little test. And so I told my family, do not use this P.O. box or phone number for anything for this time period. And we went somewhere and filled out a special offer at one of the retailers, or it might have been I can't remember exactly what it was, a giveaway or something. And I said, use that P.O. box and use that phone number. And that's the only time we used it. And it wasn't much longer until I started getting special offers from everybody across the world. I mean, everybody you could think of. So I knew through reverse engineering that was the point. There is my address, my information, my name originated at this point, and there is a business in sharing or selling that information across. We know that exists. That might not be an issue, but now my concern comes with when you add a fingerprint, or you add a retina, or you add a digital photograph to the same retailers. Is there a propensity for those retailers to then share that information as they do other information? And I think that's where the concern comes in with myself, and I think other committee members, is there is an expected, we as consumers expect a certain level of privacy even if that information is shared to a retailer. My concern is that there isn't a protection now that says if I go into a bank and put my fingerprint down, which I personally won't bank at a bank that does that, but that's, as far as regulating business, if a retailer wants to take a blood sample, in my opinion, that's their right, but I'm not going to shop there, okay? I think we're in agreement there. But what they do with that information and their responsibility protected, I do think is an interest of the public. And I'm not sure that we have right now the control or information to say, well, first of all, I think a lot of this can be defined by, or be resolved by defining who owns my information. If I give you my fingerprint, that's my fingerprint. If I own it, and you take that fingerprint and sell it to someone else, then have you committed an act of fraud or theft? So this is kind of where I see this fuzziness, or this dividing line is, I don't want to regulate business, but at the same time, when you do go into these areas, as Chairman Sessler has said, is I can't change my fingerprint, I can't change my DNA. These are identifiable characteristics of me that I can never get rid of. And then once that is established through who knows where, now we have an issue. So I think that's one of the areas I'd like for you to maybe address from the retail's perspective. What your thoughts in that? Are we expected just to give a blind trust to retailers, and probably 80% of them wouldn't do anything, but this 20% that can cause trouble? That's kind of the thought process I'm building here.
And I hear you very clearly. My question is, and I don't want anyone to give or sell or rent your fingerprint to anybody. But having said that, there's less risk in that than other personal information like your home address and your phone number and your name, which can be put on an application and a person can apply for credit. I don't want to be naive. I don't want to be over. What's what I'm looking for? I don't want to be flippant, but I don't know if any legal document I work on now to obligate myself in debt to anybody that relies on a fingerprint or an iris print or a facial print or any of the biometrics. I don't think it's going to happen. I mean, maybe our grandkids will be able to buy things with a digital fingerprint. I don't see it's happening because the liveness factor in today's society is the key issue. We talked about that earlier. You're not going to go in with a piece of paper with a fingerprint. You're not going to send a fingerprint through electronic lines, through a modem and get a product. It's just not going to happen today because the liveness issue is so important to us. Now, I don't say the first speaker talked about Orwellian ideas. Is it Orwellian to think that someday, sometimes, that would be your signature through electronic lines? I hope not. I'm not going to say it could be or it can't be. It's not anywhere in the foreseeable future. It's not in the next decade. It's not in the next 5 years. We're not going to do business that way in the United States or in the world.
Well, I think there's another aspect to this, too, that when we were debating the fingerprint issue on driver's license that came up is, depending on how the retailer's verification goes, and we talked about some really not having a verification, but I could theoretically go to a retailer and I could have fraudulent documents that say that I am John Hebner and establish an account and give them my own fingerprint. Now I have used my fingerprint to identify, at least to that retail outlet, that I am you. Now, if that information is then shared, then I have actually, through the retailer, engaged in some sort of identity theft. And so this is, when you start looking at it from different angles, that's why my concern is not that you want to take my fingerprint to do business in your retail. I might decide to do that. But is that data then going to go somewhere else without my explicit authority or my approval to do so?
And I understand your concern, and I just don't think it's a technology or a process that's going to be happening. I mean, that's just my opinion of knowing the retail industry. It's not going to happen. Things like cell phones, things like smart card, are things that are going to happen. And if you're worried about things, that's the stuff to worry about, not your fingerprint or your iris print or your face print. Well, again, it's an opt-in, opt-out thing. You know, you don't have to.
Mr. Hebner, I've got one last question. I don't know if other members of the committee. I've asked the subpoena question to most folks. And again, this really has nothing to do with retail practice. This really has to do more with personal privacy. I think a concern of the committee, as we talked early last session before we established this resolution, was just the concept of are we moving in the direction of empowering government, law enforcement, outside entities, third parties from being able to track and monitor the activities of individuals. I don't think it's fantastic to say that as this process becomes common practice and goes from being somewhat of a novelty to becoming common practice, that it will become more and more embraced by the public, whether or not the public's thought through the implications of it. And I can see examples of, Mr. Smith, we've got you on track. You submitted your fingerprint to Walmart store in Bainbridge at 6:15 on this night, and even though you live in Cobb County, there was a crime committed at 7:45 that night. 2 miles away, you happen to buy a crowbar there at the Walmart, and we think you use that same crowbar, and all of a sudden we've got access. What we're doing is we're really broadcasting biometric information around that. I don't think you as a commercial entity would have any ability to say to any party, hey, we can't give this up. Hey, if you want to use this as a issue us a warrant, or issue any store within 30 miles of this location, issue us all warrants to look for information for the individual who rendered this fingerprint as they broke into this key facility, broke into a law enforcement facility, whatever. The retail industry would be in no position to say, no, we can't give that information. We're going to protect the personal privacy of our customers. I'm just concerned that we think through the implications of what it means to have millions and millions of people per day rendering this information that in fact pinpoints them at this location and this time, day in, day out, such that over time it could be a common practice that we're in a retail culture that really rests on using biometric information.
It could come. I don't see it coming in the near future. I do say that retailers would comply with a warrant. I know good citizens try to be.
Sure.
But having said that, they could, unless you paid cash today, we can trace your transaction by credit card anyway. So it's not that different than what we're doing today. I don't see the risk being any higher than what we are. In fact, I see the risk being lower with biometrics than I do with current technology.
Sure. Mr. Evans, I really appreciate your time.
Thank you so much. It's been a real privilege.
Absolutely. Again, we continue to be a little behind schedule as a committee. I've got 10 minutes till 3. I'd like to call forward one more group before we consider a short break. We've got Elizabeth Chandler from the Georgia Bankers Association. And Ms. Chandler, we've got your program for 45 minutes, but take as much time or as little time as you need.
I'll pick it behind schedule. Exactly. It's time to go. I wish I did. Mr. Chairman and members of the committee, thank you for having me. My name is Elizabeth Chandler, and I'm the Senior Vice President for Government Relations with the Georgia Bankers Association. The membership of the GBA is comprised of over 360 commercial banks and thrift institutions from throughout Georgia. Upon being invited to join you today, I've attempted to gather the latest information on the use of biometrics being utilized in Georgia banks today. While it appears that there's little usage at this point in time, the banking industry remains optimistic that known technologies are improving every day, and new technologies are coming on the market which there may be a need for in our industry. The issue of identity theft is paramount in our everyday thinking, and the case can be made that the use of biometrics can and will go a long way toward protecting the privacy of our customers, as well as sensitive information inside of our banks. Biometric-based solutions can provide for confidential financial transactions and personal data privacy, network security infrastructures, secure electronic banking, investing, and other financial transactions are already benefiting from these technologies. While some banks have begun using biometrics for customer and in-house security, they do seem largely to be in a testing phase, though. However, there are several recent developments worth noting. Biometrics received increased attention from the banking industry when the Federal Financial Institutions Examination Council, it's a mouthful, told bankers that single-factor authentication, such as just a password, is inadequate for high-risk online transactions, and that they must perform a risk assessment by the end of this year and toughen their authentication systems. That would be for online banking. Bankers have begun testing secret questions, password-generating tokens, and biometrics to improve online security. Also, we understand that federal employees will be issued new ID cards this fall, which will require fingerprints and possibly retinal scans or other forms of biometric identification, depending on the agency. And that card will be used to gain access to federal facilities and possibly ultimately to grant access to computer applications. Our industry, as well as others, will likely borrow from these new standards for government workers. At a minimum, the widespread use of biometrics by the federal government is expected to drive down the cost of the technology, which could spur adoption in the private sector. One larger financial institution now uses one form of biometrics, fingerprint authentication, for its branch employees. Previously, branch employees had to sign on to, in some cases, more than 15 systems, and each system required a separate password that changed monthly. Some employees had so much trouble remembering that obviously they wrote those passwords down, and that obviously works against the value of the security systems. Now, those branch employees can sign into all systems by putting a fingerprint on a reader. This particular bank pilot tested the system in 2003, and it's been in place in all of their branches for over a year now. In another case here in Georgia, the use of hand geometry is used when allowing customers into the safe deposit box area of the bank. The system is a standalone system within the branch. The hand geometry scan replaces the signature verification usually done by a bank employee. The system is a so-called one-to-one recognition system whereby the user inputs a 4 to 10-digit PIN number and then places their palm on the reader where the hand templates are stored. The system then determines if a match is made using both the PIN with the hand template stored in the memory. It takes a match of both factors to allow the customer through. Other biometric technologies that we understand are being explored by banks include voice recognition and digital signatures that could possibly be used by both bank employees and customers for personal verification in order to conduct business or change their user passwords and things of that sort. They would likely be used in conjunction with a second verification factor, though. As for privacy concerns, possibly no other industry takes customer information as seriously as the banking industry. This includes any biometric data. Any bank that already employs biometric technology did not do so without exhaustive testing as to the security of the system. This exhaustive process sums up why biometrics are not used more often in the banking industry, and we would not move forward on any new system without the full faith and backing of the technology industry and, more importantly, our regulators. In conclusion, while the use of biometrics in the banking industry is in its infancy, the prospect of this convenient technology is seen as considerably more accurate than current methods, and the banking industry is committed to the protection and privacy of our customers and our internal systems. Therefore, methods that step up that level of personal protection are worth exploring in our minds. And that is a brief overview, and I'll be happy to try and answer any questions.
Members of the committee. Representative Cooper.
I'm curious about, especially as we look at transporting our medical information with us, what are the statistics on the breach of the, I mean, I don't use the automatic banker, so, because I figure I would do it at 1 o'clock in the morning after session at the wrong place in downtown Atlanta and get mugged. So it's just better that and I probably wouldn't remember my password, so I'm one of those. But how often is that system breached and somebody gets money out of somebody's account? I mean, it seems like if we can go to automatic tailors and get money out of our thing, and we can use a credit card, you know, at the gas pump, that we ought to be able to make our medical information secure. So I'm curious, is there a great deal of problems with that system? Do people get that information, or do people lose money out of their accounts frequently? What's the background on that?
I don't know that I could give you any firm statistics. I can tell you that bank security is an industry in and of itself, and it's certainly something that we work every day to stay a step in front of the criminal element on. Clearly, there is some identity fraud in our industry, like all others, but something we're working on every day. So I'm sorry I don't have any hard and fast statistics for you.
Representative Letterman.
Really, mine's the same question I've asked most anyone who's in previous meetings and this one today. Is without a doubt, biometrics is here, and it is there is an element of security to protect my interest in there. So it's especially when we're talking about private business and private industry. My concern comes with not as much the use of biometrics, but the protection and the distribution of that information that once it is obtained. For instance, you mentioned the hand geometry used to protect safety deposit box. It's undoubtedly a great way to protect that safety deposit box. My concern comes is when I no longer am using that safety deposit box, is there a regulatory statute in place or a common practice in place that says once I no longer use that safety deposit box, I'm not renting it or whatever, is that data destroyed? If I no longer have an account with a bank, is my fingerprint data retained or is it destroyed? That's the really where my concern is as Representative Setzler has said, that's information you can't change. That's information, in my opinion, that you own. And I think that's really where I'm looking in this is there a standard out there federally, statewide, or within the industry for, one, protecting that biometric data that is used so it's not subject to an incident like Choice Point or something like that. And two, is there a policy or regulatory precedent there to dictate retention of that data? Because basically if you have the data, you have to protect it, and there's a responsibility. But I'm not sure as a government or a society we have established what that responsibility is, especially with the biometric data.
I think banks are unique in the area of record retention because we have hard and fast guidelines on that, and it depends on what the record is, whether it's loan data or whether it's personal identifying information. But at some point in time, if you're no longer a customer or if we no longer have a need for that data, then it's destroyed appropriately. So I think that, again, we are a little bit unique in that area. You mentioned the hand geometry data. It's a unique system in that it's not exactly a picture of your palm. It's there's several pictures taken from different angles, and then there are measurements taken. It's a system based on measurements of your hand, not like your individual fingerprint. So that's just a little difference in that technology there. And you mentioned Choice Point. The issue of data breaches are large on our radar screen, and we spend an awful lot of time talking about it. Banks have been required for some time, since the passage of the federal Gramm-Leach-Bliley Act about 7 years ago, to have a system in place whereby if there is, heaven forbid, a data breach, then we have those notification requirements of our customers. And right now, it doesn't say, the FDIC guidelines don't say biometrics. It's a long definition of sensitive personal information, and I think from what I gather, we already know to count biometrics in that definition, but I think they're going to expressly put it in there. Mm-hmm.
Any other questions for the committee? Well, I tell you, in the interest of time, Ms. Chandler, I think we're going to move on. Is there anyone in the audience that has specific questions for Ms. Chandler while she's here talking? Anybody? I want to give everyone a chance to pipe in. Anyone else in the committee? Ms. Chandler, I appreciate your time.
Thank you for having me.
Absolutely. Is it the pleasure of the committee to take a quick break or press on? Okay, I'm going to appoint Ms. Nuremberg, our committee assistant, to be the timekeeper here. She does a better job of that than I do. I've got 3:05. Let's be back in here at 3:15 seated. Again, I'd like to welcome Mr. Jim Flowers from the Board of Regents. Initially, we had looked to reach out to representatives of the Department of Education to talk K-12, and then the Regents to talk higher ed. I did talk to Jim briefly and say we might ask some questions that would apply to K-12. There's certainly been some publicity regarding this issue in K-12 in the last 3-4 weeks that have made the papers. Again, we're not newspaper-driven; we're issues-driven. But that being said, there's certainly public awareness and public interest, and I would appreciate Mr. Flowers coming and being able to share both in breadth and depth on these issues. So, with that being said, Mr. Flowers, welcome.
Thank you, Mr. Chairman, committee members. I think I will follow Ms. Elizabeth's example of keeping things short and to the point. There's one of the unique things about universities, while we profess to be technology-driven, research-driven, and on the cutting edge, getting our faculty and getting our bureaucracies to change is just as difficult as any other government and large corporate bureaucracy. So therefore, we're not necessarily on the cutting edge of some of these neat new things that are coming along. And that's both good news and bad news, depending on your perspective and what's happening. But it's a pleasure to be here today and to talk to you about these issues. And I may qualify myself as not being an expert at times, but we'll certainly get you answers from those that are more expert than I, if necessary. And we look forward to cooperating with the committee. Real quickly, I've asked that a one-page in its front and back outline of what I'm going to talk about be handed out. I've been in the tech business since 1978, and it seems that the more mature I get, the less technology I like to use. If I can get right to the paper, it's good. I'm going to talk about education, research, healthcare, and then in some general terms, public policy frameworks, and that's really more a work product of what some of our researchers do than how we use the technologies in a business process. But first, we'll get right to our main core mission in education. We have over 259,000 full-time students registered. That is our best numbers as of today. Some people think we should have better technology tracking the students, so we can give you exact numbers today, but that is what we have. Typically, in terms of the bioinformation that was described in some of the materials I received from Jennifer, about the extent of the bioinformation we collect on students or what's on ID, and everyone's seen the picture, the signature, and they have a barcode on the back. And most of our institutions have gone to a one-card type system. So, in fact, I've just recently begun as a student again, and it's kind of neat to go up to a Coke machine and swipe it and get a Coke, or to go to the copy machine and swipe. As long as I've fed my account with some money, it will let me do what I want to do without me having to run out to the change machine or what have you, which, when I was last in college, that was you had to carry quarters everywhere, or you just couldn't do anything. So, the technology does have its advantages, but short of that, the system really doesn't know what I'm up to or what I'm doing, except for, the education record that I create for my performance in class. And that's true of all students. Of course, we all had to submit immunization records, we have health care records, and those are all protected under the Hipaa standards. The information we're allowed to publicly disclose on a student is limited to what we call directory information: name, phone number, perhaps an email address, and that's about it. We can't even tell parents certain things without waivers signed by the students, and that has pros and cons to it, but those are the guidelines under which we operate as the federal government tells us. In fact, as I go through my little talk, you're going to find, as I told Mr. Loudermilk earlier, we have so many regulations around us, it's like we live in a bowl of spaghetti, and I probably can't say much at all, but that is the way it is. Not only do we have HIPAA, which takes care of the health information of students, and FERPA, which is the Federal Education Rights Privacy Act, which began its life in 1974 and has been amended several times since, takes care of students' education records and a lot of the other information pertaining to students at our campus. We've even found out recently that Graham-Leach-Bliley applies to us as a financial institution if we take credit card information or have other financial records dealing with students. Our associations are kind of protesting that. We think that's been a stretch by the FTC, but be it as it may, we're subject to those compliances. I actually have a whole presentation on security compliance issues related information, and there are several slides of federal laws and regulations and state laws and regulations that attempt to help us protect information and access to information. So many, as a matter of fact, we can't afford to keep up with them, much less know if we're in compliance with them. But we aim for the ones that are important and hope that we're doing a good job, and that's just the nature of the beast when you have so many agencies that regulate you. In terms of security, though, yes, our campuses have video cameras, but none of them use identification technologies such as we heard about at the Super Bowls, where Tampa, I believe, is using cameras in the city and by your gait or other behavioral motions could potentially identify you. We certainly don't have those. Our cameras are more or less after the fact and hopefully preventors and saying, hey, there's a camera watching you. If you do something, then we can go back and review the tape. But it's certainly not stored in a biometric fashion where each and every individual recorded on tape then has that plugged into the record. Oh, that was Jim going from the student center to the library at 2 in the morning. What's going on? That's just impossible to do. We are required to keep track of students and whether or not they attend class due to visit regulations. And visit is an acronym for federal rules related to immigration and international students that are on our campuses after 9/11, and it turned out that several of the individuals involved in the unfortunate instances came here on student visas and never went to class. The Fed said, okay, you need to start telling us if they missed more than 2 days of class. It's maybe 5 days now, but they started off at 2. But there was also state legislation. I mean, it was a reaction at the time saying you should know who's in class, and of course all of you who've been through college know that going to class is your business. If you're not there, you're going to be failed, and that's the contractual relationship you have with the professor. But from a security point of view, law enforcement said, no, if there's an international student, you better know where they are, and if they don't show up, we need to know because of past pattern. And just for international, yes, ma'am.
When did that start?
The rule was proposed in 2003 and became effective late 2003, early 2004. The big deal there has been struggling with the computer systems. We have to literally walk the data from one system to the next instead of having an automatic interface. But those things are supposedly being worked on. But be that as it may, professors are obliged to inform everyone in class that should you miss X number of classes, they must report your absences to the dean, who then takes appropriate action depending on whether or not you're an international registered student or not. So, the other activities that we could see where technology is leading us to use some biometrics would be in distance education. And of course, a number of different pressures are on us to expand access to education. Certainly, limitations on capital budgets force us to be creative. are to be very efficient in using our building space for classes, and some of those solutions are to either go to hybrid schedules where we say half the time you're online, half the time you're in class, which doubles our class space right there, or to say it's all online. But then you have a question, do we have the dog taking the test or is Jim taking the test? You don't know, other than the login ID and other information we may collect at the time. Certainly a means of biometric identification would give one a deeper level of assurance that you are who you are if you're taking an exam online, for example. But those things have not come to fruition yet. I have a feeling we'll see the more commercial enterprises such as University of Phoenix come out with that technology long before, say, a public university would. We do have other uses of video in sports and football, and I can tell you they database every move of every player, and they do trend analysis and behavior analysis. And I actually had a roommate 20 years ago who was writing software for Auburn to do just that kind of analysis based on the films then. So an unintended consequence, perhaps, of restricting what data we collect on video could be affecting the football team. I say that in jest, but research is another area we have a lot of business in. And technology in general, I can't point to any whiz-bang nanotechnology or whatever. We should all go cower under the bed, or I should write Michael Crichton to give him an idea for his next bestseller. But nonetheless, we are in those areas. And of course, that is driven by both federal demands, market demands in general, businesses, and science. Can't predict which way that's going to go. We just don't know of anything on the shelf or boiling in the back beakers that would cause a lot of concern at this point. We do research in a lot of federal departments. They do impose security requirements way beyond anything we would require normally of our employees and our students, and we do have some students that work in those labs. We don't have any control on that. Security systems they place, which do use biometrics, are monitored by the federal agencies and the security agencies, and they audit the compliance with the equipment, the use of the equipment, and in short, it's not our business. We just have to use it. And I really don't have lots of details going on there. I know there's some things at Tech in that realm. I know there's some things at Georgia and some of the biology research. But those are all DOD or DHS or other appropriate federal agency safeguards and security measures.
Mr. Flowers, could you speak to what those things are? Do you have any sense of that?
Some of them are as simple as a finger scan. There's retina scans. Of course, there's a lot of background checking going on before you get the card that allows you to even get to the point of getting the second or tertiary check on your identity. And then you're in a black box. And I have no idea what goes on in there. That's part of the rules.
Okay. And these are generally technologies that are defense-related?
They're defense-related. They're what you see in the Pentagon or any top-secret or higher classification facility.
Okay.
Like I said, that's what they require us to do in return for doing the research.
Okay, gotcha.
Healthcare, of course, the Medical College of Georgia not only is affiliated with this hospital and provides healthcare, also does research. And I put them down here as an example. Any of our institutions that does research that involves a human subject. And on the one extreme, that's as simple as a survey, a social science survey. It must go pass under the checkoffs of an institutional review board, which is a committee that says, are you going to harm any of the subjects? What guidelines do you have in place, et cetera, and so forth. And how are you protecting the data, and what kind of data, and those kinds of questions. There is actually a standard for behavior and process of these boards that is nationally and even internationally recognized. And so whether it's medical research, which has the nth degree of checkoffs, or something simple as social science research, which probably is, I don't think would be anywhere near as severe as what you would do in terms of making sure that medical research is not harming someone. Those reviews, and it is more or less an independent assessment. They can halt the research or prevent it from ever taking place if they feel there aren't sufficient safeguards in place, or if they feel it could harm the subjects that are involved in the research. And so that I just bring that up to the committee's knowledge as far as how we have checkoffs in place in such research. Now, the policy frameworks, and I and Chairman talked a couple of weeks ago about trying to see if we had sufficient policy experts, people that study public policy for a living, and actually that's what I'm trying to get my certificate to do. And I spoke to several at Tech and at University of Georgia and at Georgia State, and they all had a piece of the puzzle, but not the whole puzzle this committee is addressing. One of the suggestions I had that was most constructive said, look, we'd be more than willing to sit one-on-one or many-to-one, whatever you like, but in a setting where it's really an informal 2 to 3 hour discussion of the various aspects of this problem. And I just put a few down here on the handout. Everyone agreed this is a very challenging and interesting idea, and it does touch everyone's lives. But there are a lot of different perspectives to consider. It cuts across a lot of interest groups, as I know you've heard in your testimony, a lot of jurisdictions, and there are a lot of perspectives. What you're doing could affect commerce, could affect research, both positively and negatively. I don't mean to be judgmental about what I'm saying here. Could affect our position and competitiveness, either as a state, a locality, or a nation. And it could be, I wouldn't say it's mundane, but it could be as straightforward as customer service. And as you know, the governor is pushing faster, friendlier, and easier as a model for state customer service. And just like Amazon and some of the other e-retailers that collect information of what you like to do, how you like to do it, so they can be more responsive to your needs, we can see where that would be something that not only education but other agencies of government will want to use in order to be more responsive to the public. So we just have to kind of look across it at both the good and the bad of technology, so we try to come up with policies that deal with that. And as I said, these individuals will be more than happy at a date convenient to the committee to meet and discuss. But none of them felt they could do it justice in 10 or 15 minutes, and so they deferred at this time. So with that said, that was all I had to say formally. If you have any questions, I'd be glad to try to address them or to find you the appropriate answers.
Again, thank you very much for your presentation. And again, I'd like to turn over to members of the committee. Again, without a representative from K-12 education, I certainly contemplated being able to discuss educational environments broadly, equating some basic needs in a regent's environment being very similar to other educational environments. Are there any questions to that point that we could address to Mr. Flowers while we've got him?
I do have one question about the presentation. FERPA, does that apply to private institutions as well, or
yes, it does.
Any post-secondary?
Yeah, I believe the hook is anybody who receives federal funds, but student loans or whatever, so that pretty much touches everyone by default. So that's K through 12, and it's technical colleges, community colleges, universities, profit and not-for-profit. Now, I think there are some cases of extreme proprietary institutions like the LA Music School for Grunge Rock, which my son is interested in. We may need to talk about that for legislation, but nonetheless, they might escape if they don't accept any federal funds whatsoever, but they would be an extreme minority.
No, is the FERPA simply for, does that deal with K through 12 at all? Or
Education.
Yeah, it deals with all the educational records. In fact, you know, as the accountability movement is progressing, and Secretary Spellings of the United States Department of Education had a press conference for her action plan on higher ed accountability, and we're talking about a K through 16 or above record that follows the student. And that has certainly been a goal within the reform efforts in this state, I know, is understanding, okay, as a student moves through K-12 and then goes through secondary and post-secondary education, how can we see what the product of the various systems are and if they're succeeding or failing, et cetera. And I know there are some efforts on behalf of all the education agencies in this state to help with that transfer of information, so we can go up and down the river of information to see which programs affect what, how, and which we should disband and which we should improve, and et cetera. And certainly it's part of a national movement in looking at standardizing not only the records but how we measure our successes in higher ed, which higher ed tends to be a little loosey-goosey around what's good and what's bad in terms of education. Of course, there are thousands of years of tradition there, and that comes into opposition sometimes with change. But those movements require some standard level of access to information about each and every student, no matter where they're going or attending school. And so those records fall under the federal jurisdiction. That's what FERPA is all about.
Now, I don't know if that applies to, and before I walked in, I know that you were touching on the issue with one of the school districts in Georgia has broken into a new arena of taking fingerprints from children before they get their school lunch. And I believe the issue from talking with others is not as much in the, I have an issue with I don't know why we'd need to do it in an elementary and school setting, but is that this was done without notification or consent of the parents, and the children were not given the option to opt out. I know you might not have any information on this, but if you had any, does FERPA deal with any of this? I mean, because we're talking, I guess, two realms. You're with the Board of Regents, which most of those students are in adulthood and they're going to answer for themselves. But when we're talking K through 12, you're usually dealing with a minor who is the responsibility of a parent and doesn't have the capability to make those wise decisions. Of course, I've got a teenager too, and I'm wondering if sometimes, even though just they've reached the 18, if they can still make those wise decisions. But if you have any background or information.
Well, I saw the same video report you may have seen of the school. I think it was in Rome that was using it. And I think their justification is, hey, it's quicker and more efficient than the old way, and I can understand that. Now, as a parent, and that's the viewpoint I'm going to give you now, is as a parent, I would appreciate the notification, and probably with a reasonable explanation, I'll go, okay, fine. Maybe not, but, you know. They use a fingerprint scan on your index finger to check off that you got a lunch that day.
Oh, and you pay for it in monthly or something?
Yeah, and so it's just checking. It says, oh, Jim got a lunch today. Knock, you know, it's $2 or something now, isn't it? Off your account and so forth. I know University of Georgia, we use a hand scan in concert with an ID card for access to the cafeterias and to the Tate Recreation Center. I dug into that, and it turns out they've been doing that since 1972. And technology has improved over time, but and the information on the hand scan, it starts off as two-dimensional. It's a little more complicated today, but it's unique to that system, so it can't be used anywhere else, and it just ties you to that card. So it says, oh, that's Jim with his card. Jim didn't loan his card to somebody. And so, you know, the folks that run those facilities are trying to be accountable and responsible and make sure that facilities are used by those that pay for the facilities. But as I checked, you know, I was shocked and surprised. It went all the way back to 72. I didn't go to Georgia, but I would have thought my friends would have told me about it, but so be it. But in question of the FERPA information, they're very, very strict about releasing any information other than basic, you know, name and yes, they're here. As a minor, I think that may be even more restrictive, but I would have to go to someone else that's more. FERPA is really thick, and when they issue a rule as simple as whether they'll accept a digital signature, it takes 6 pages of fine print. Now, the good news is they gave rulemaking ability to the Department of Education, so there's flexibility. They can deal with the year-to-year adjustments as new technologies or events occur, and you don't have to go back through the legislative process, which we all know can sometimes be quick, sometimes not. But I believe in school of management. You hire responsible people, give them the guidelines to operate. If they misoperate, you fire them. If not, you allow them to do the business, and you can be more effective.
Thanks.
Mr. Flowers, the question I have centers around establishing a clear need. I think, you know, we talked about before, most every entity that's going to collect biometric information is going to do what they believe is adequate in terms of safeguarding and protecting it. I mean, I'm assuming some level of good faith. And most of the ones that have come and talked to us today have demonstrated a compelling need for one reason or another for collecting what they collect, whether it's medical information that looks at DNA or other things for looking at medical or potential medical conditions, the obvious security needs associated with financial security, security issues tied to retail transactions where they want to, you know, there's theft issues, there's identity issues with credit and so forth. But again, you have to look at making the compelling case for each potential disclosure of info, and in essence, it's not anyone's opinion. It's a fact that this information represents a Fourth Amendment search, and you'd think there'd need to be some reason to compel someone to do it. And you look at retail. I'm just kind of prefacing a question I'm going to ask you just by reference of context. I mean, you look at a retail outlet. If one retail outlet requires to use a credit card, you submit a fingerprint. You can make the decision in the marketplace, I'm not going to choose to patronize that outlet. I'm going to go to this outlet and shop in this store. In the context of banking, you can make that same decision in the marketplace. But in the context of schools, be it K-12, be it the regents, unless we're going to take the position that if kids don't like it, they can leave the state and go to New Hampshire and get a college education, there's questions of really access to basic things that we consider to be fairly fundamental, which is access to an education. So with that as a preface, are we not treading on different ground in the context of education, where if students were required to give up information as a means of being in the student body of a public school, a public higher ed institution, aren't we now treading on different ground, where if you want to go to college in Georgia and get a public education, then you have to submit to a Fourth Amendment church. You don't have the ability to go and say, you know what, I'm not going to choose to go to Walmart. I'm going to go to Target because I like the way Target treats me versus the way, and it's, or Walmart versus Target for purposes of the cameras. So I asked that question, do you see any compelling reason from a higher education standpoint, from a security context, that would be compelling to say every student ought to be required to give up biometric information?
Well, first I would ask for a very strict definition of biometrics to give you an answer. But if we're talking abstractly and in terms of some philosophy there,
handprint, fingerprint, you name it. Iris scan.
One could say it's part of a contractual relationship. If you want this service, this is what I require. If you don't want to give it to me, that's fine. You just can't have the service, and be that as it may. We have no such requirement other than proving to us that you are Jim, that you do belong to your educational record, and that you do belong to your SAT score and any other data you've submitted for us to accept you, and that your money is good. As far as admittance into a public school or of higher education, yes, we do have some business services at UGA that require the hand scan, and we do have employment requirements where defense and other security needs may require more. Those are all conditions of participation that you may elect not to participate in, and that is just choices we have to make as we go through life. It's just part of it. As far as requiring things that may deny access, I don't foresee a need from the education community's point of view where that would be the case, unless some security requirement that we can envision right now. We all know the world changes very rapidly now. Comes down on us, and that would probably come from the federal government more than likely than the state government, that says we have to understand each and every student, where they are, that they are who they are, and can report that. And I can assure you that the community, the education community, especially in higher ed, is just rebellious enough and independent enough to they'd probably stage a revolt over that stricter requirement. But again, we all are servants of the state and of the public, and we do what we're told to do, or we choose employment elsewhere. But I'm not trying to evade your question. I just don't see the need coming up administratively where we'd have to do that unless someone compels us to place that need.
You got to ask the question because, again, I think we can make the case within Georgia. We're K-12 education, I mean, you can certainly go to a private school and make those kinds of choices, but within the framework of public education and public universities, I would certainly, I think it's a policy discussion. Should you have to submit certain information to get an education in Georgia? And maybe it's okay. Maybe you're a conspiracy theorist, though, and think, I don't think the state of Georgia can protect anything. I don't trust them with that, and I'm not in a position to make a market choice to go there versus there. And I think that's a policy discussion we can have.
It certainly is, and we'd be glad to help along those lines. We wrestle with those issues both theoretically and practically every day. So,
one follow-up to that, if I could, it's related. I was thinking about kids in a school lunch line with parents being uninformed. Are there things you make within the university system that you make a distinction between adults and unemancipated minors? I mean, is that a distinction to make there? Because certainly in an elementary school setting, these are not, quote, adults. The parents are the ones who are legally responsible to make those decisions. And can a child submit to divulge their information, and is that an appropriate decision for a child to make, or is that something that would be more rightly in the hands and of the responsibility of parents?
There is a gray area for those that are under 18 that attend school at our campuses. I'm not an attorney. I can't get into the details. Of course, the doctrine of in locus parentis has undergone some modification where the college effectively became your parent and would deal with the police if you had an infraction or things like that. I don't think those days are here anymore. But nonetheless, there's assumed that the administration can act on a minor's behalf in certain instances, and then, of course, in contact with the parents. I think institution by institution, they may have particular things they work out, and I would have to go survey and get you the right answer on that. I'm just giving you a very general view. That's a very small portion of our student population, but most of those individuals that are they're either within a few months of being 18 or they're extremely bright and capable kids. And we have had some get through by 16 and be on their way to a PhD, so that happens very rarely. Now, you were talking about earlier about some of the information required. Probably the most intrusive that occurs now is the identity you must hand over to the test givers, the education testing board out of Princeton that does the SATs and the ACTs. And certainly when I took the GREs last year, I had to give up a thumbprint and a photo, so they say, yep, that was Jim walking behind the door, and he got locked in there for 4 hours. I took the test on computer and walked out. The nice thing was it was scored. I didn't have to wait 6 weeks, but it was convenient. At least no anxiety there. But, that was because of a reaction to some test fraud that's occurred both at the SAT and the graduate and LSAT and all the other standardized tests that are sold and given for access to education. And that's a private testing concern, not for profit, but private. And that was their reaction in response to lawmakers, both federal and state, saying, hey guys, you got to tighten this up because we hand out scholarship money, loan money, et cetera, and there's got to be accountability. And so it's not our requirement, it was their requirement. Certainly we need access to the test scores to qualify a student, but it's a third-party arrangement.
Any other questions of the committee? Hearing none, any questions from the audience of Mr. Flowers while he's here?
I don't have Georgia, Tennessee tickets. So.
This weekend?
Not this weekend either. Those things are tough. I think tech tickets are getting tough, too.
Yes.
Mr. Flowers, appreciate your time very much.
Thank you.
Sharing with us. I think we're down to our last speaker, Mr. Kim Kimbrough from the County Commissioners Association. This man is known for his brevity in this building, and we trust he'll live up to that reputation.
Absolutely, Mr. Chairman. Thank you very much for placing me last on the agenda, because that puts me in a position to help you out, send you home with a smile on your faces. I'm here today, of course, I'm Kim Kimbrough from the County Commissioners Association. I'm assistant counsel there, and I'm here to speak to you guys about local governments and our role as public employers, which puts us in a different framework when we're speaking about the Fourth Amendment and constitutional protections as a government actor, because we're in our non-prosecutorial capacity. When we're collecting data from folks at this point, we are not seeking it for prosecution purposes, and the Supreme Court has held that what we're doing there is has to be a balance between a compelling governmental interest versus that person's individual rights, and that's a case-by-case, fact-specific balancing that has to be made. And so there are certain things that we're allowed to get and certain things that we're not allowed to get, and I'll just throw out there, even though it's not a biometric directly on point issue, but random drug screens. And random drug screens blanket for all public employees? No, bad thing. But people who either operate machinery, are vested with weapons, vested with custody and control over persons who are vulnerable, and that's not just jail inmates, but folks who are working in our healthcare settings. Those folks, sure, the Supreme Court in case after case has said, well, you have a compelling interest there to protect the citizens and in these services you provide, and so your governmental interest is compelling and overrides that person's individual rights. And so I see that in future cases where biometric data gathering is going to be challenged for public employers, probably that same sort of analysis is going to occur. So it's going to be incumbent upon governmental actors to find some compelling need to collect that data. I think the other issue that we've got hanging out there from a legal perspective is the Open Records Act here in Georgia, and of course the Freedom of Information Act federally. Things that might not otherwise be a problem for private businesses to collect in terms of information, and they can protect that information short of discovery in a civil proceeding. Anybody can request any records or data that's held by a government, and short of the few protections that we have enacted, name, social security number, maiden name, and address now of all public employees, short of that, and of course we would have to go back and specifically address any biometric data because they are not contained within our current definitions of protected information. Anybody can get that information under open records. And so there's no protection for that whatsoever.
I'm hearing you say that there's no protection from open records for data beyond those specific items you've listed within public employees. So if there were biometric information collected or even drug test information collected, that would...
Well, drug test information would be protected under the medical protection.
Okay.
You've got both state law and federal law protections on that, HIPAA, and then we also have state law protections on drug tests and confidentiality of those tests. But because we go through, and first of all, the Open Records Act has to be construed broadly and any exceptions construed narrowly, and that is because of the spirit of the Sunshine Law, that everything that is done by the government is on behalf of the public. The public has the right to that information. Once again, exemptions are narrowly construed. So if you say name, address, phone number, that's it. You can't say, well, you know, your fingerprint is part of who you are, and that's part of your name. No, it doesn't work that way. Name, address, phone number. So if biometric information is intended to be protected, that's going to have to be specifically addressed in the Open Records Act.
So a following question to that is, let's say a sheriff's deputy. By this, what you're explaining is that his name or address and some personal information about him can be protected from open records.
That's correct.
But not any of this biometric information.
That's correct. And I'll give you, for instance, this is kind of, we have not yet seen this, but it's kind of one of my nightmare scenarios representing public employers, specifically as it relates to police officers and other people who are accessing sensitive areas. If you're using an RFID card to gain access and protect access, I'm waiting for somebody to say, I would like to have the access records for Deputy Kimbrough on the days that he entered the jail and left the jail. I don't believe that would be protected under our security plans. I don't think that would be protected under our Homeland Security, because we're not divulging a security measure at the jail. We're not divulging the location of the jail or any of the other things that we might consider sensitive about the jail. We just want to know when was Deputy Kimbrough in and out of the jail. And actually, and for a defense attorney's purpose, and of course defense attorneys do heavily use the Open Records Act, that might be considered material to something he's trying to prove about when I entered and left the jail. But because I have an RFID card hanging off my collar, he should be able to get that, because there's a database that keeps track of every time I came in. K. Kimbrough, 6:45, this date. So, and that's not protected. And the Open Records Act, I mean, I think sometimes, maybe that governmental bias. I mean, one of the things about the Open Records Act is that even though it's intended to shed sunshine on what we provide for our citizens, what we hold in trust for our citizens, anybody can use the Open Records Act. You don't have to be a citizen of the state of Georgia, a taxpayer in the state of Georgia, in order to avail yourself of the Open Records Act. You can be somebody from Texas. You could be somebody from Puerto Rico. You could be somebody from anywhere, anytime, and avail yourself of those Open Records Act protections. And maybe that's a good thing, maybe not. That's for the General Assembly, for your sense and wisdom.
Mr. Kimbrough, I'll let you keep going. I do have a question I wanted to which you may address later. You were talking about no blanket drug screens for public employees. You've got to make a case as to why the performance of their duties would specifically require that. How does that apply to private employment? Is that specifically public employment you're talking about? Or do companies as a policy in a right-to-work state still say, companies do it all the time, as I understand?
Sure. And the public employer, once again, because of our governmental nature, we are bound by the Constitution, whereas the Constitution, the Bill of Rights, only acts against governmental actors. Doesn't act against private corporations. You can't make a constitutional claim against a private actor, because private actor is an individual. All rights not specifically enumerated for the government are reserved to the individual. So the Constitution is there to restrain government. So you don't make constitutional claims against private actors. You make individual claims. You make an invasion of privacy claim. And, of course, you have a separate legally defined theory of what your rights to privacy are. And they are personal to you, and they are not necessarily protected by the Constitution per se.
Clearly, I'm not a labor lawyer. So as you go through this, I'm going to ask a couple of questions about how it might apply to private employment. But, again, I'll let you get back on.
Well, and that's an excellent segue, because one of the interesting kind of crisis points that I see governments approaching is that there is ever more pressure for governments to operate like businesses. And, of course, as we're trying to achieve the efficiency of private businesses, we would like to avail ourselves of technology such as what we've heard some of the representations here today. I mean, we'd like to be able to verify eligibility using technology. We'd like to verify that our services are being delivered in an appropriate and timely fashion to the folks who pay for it. We'd like to be able to track our resources and manage our resources. We want to know where our trucks are in the field. We want to know if our employees are showing up on time. We want to know how much time they're spending at work, off work, on leave, sick, healthy. We'd like to try to help our employees stay healthy to reduce our health care costs. All those things are things that in the private sector, private business can do that at the snap of a finger, and there's not much concern other than in the marketplace and marketplace forces for what they're doing with that data, how they're collecting it and maintaining it, managing it, and using it. However, the public employer, as the government, we stand in different shoes. And frankly, I think that's part of what's holding us back, because we don't want to address those issues. When we start to collect biometric data for perhaps verification of eligibility for services, what do we do with that data? I mean, it's now going to be potentially unprotected from Open Records Act, and we're going to be strictly liable for any misuse, for any breach, for any abuse that comes out from that. And so, oddly enough, I think a lot of government employers are just staying away from it because it's risk averse. And certainly as an attorney, I would counsel my clients, you might not want to go there. If what you have now is working, let's not venture into that territory until we can see some additional protections, and we can figure out how to do this without breaking the bank. Another interesting crossover there as well is privatization. One of the wonderful things that we do have is we have the contractual ability to contract out for services, garbage collection, health care, water and sewer, any number of privatized services. We can privatize an entire city now. However, the Open Records Act applies to private actors acting on behalf of governments. So just because they're private actors doesn't mean that they evade that review. If that were the case, I think if you could evade the Open Records Act by privatizing, you have a lot more privatized governments. But so certainly, once again, that's a pushback. And if the private businesses are availing themselves of this technology, once again, now we've opened up those records and that data to disclosure, because we're governments and we're different, and there's different expectation, different legal standard that we're held to. Finally, as it relates to security, I think we have pretty much covered the protections for security, and that's probably the third biggest area behind resource management and verification of eligibility. That's the third biggest area where you'll see government employers using biometrics and RFID technology in their day-to-day operations. There are sensitive facilities that must be secured. There are sensitive pieces of equipment that we have to track and maintain. And so you will see a heightened use there. But we still have not yet gotten to the point where you'll see the super secret facilities where we're doing retinal scans and fingerprint scans and that sort of thing. However, what's coming is that in addition to, and y'all have already covered the Real ID Act for just the driver's license and citizenship source of information, but we also have under the Homeland Security rules now, under the National Response Plan and National Incident Management System, we're going to go through here shortly within the next 2 years a period of credentialing, whereby all Homeland Security responders are going to have a standardized type of credential that identifies them by the type of responder they are, who they work for, and certainly, just as we've talked about federal employees, they're going to be instituting a very serious use of biometric data to verify their identity. That same sort of philosophy is going to cross over into credentialing. Now, what does that mean for governments, particularly local governments? Homeland Security is no longer just fire, police, and law enforcement. It's now public health, public works, water and sewer infrastructure, because those are the things that we're going to have to respond and recover in the aftermath of a disaster, man-made or natural. Those folks are going to have to be credentialed, and that's going to be the majority of our governmental workforces. So the person who, on a day-to-day basis is just out digging ditches, still going to have that federally mandated ID hanging around his or her neck with the fingerprint and whatever else the federal government requires, because in time of disaster, they're going to have that credential in order for us to have them respond to their neighbors, either here or in another state, in order to respond to an emergency. And just as in the Real ID Act, we're going to bear the burden of not only equipping them with that credential, but then we're going to have to store and maintain that. And we only hope that there will be federal law protections, as we've seen in some other areas, that will say this data must be protected. And of course, under the Open Records Act, there is a specific provision that says that any information that is protected by federal law is protected herein also. So those are our concerns and those are our uses.
Wow. I think we're really getting down to the heart of some of the issues we've talked about here. Before I ask a question, the Will make comment. It was refreshing to hear someone, especially in your position, to make the statement that the Constitution exists to restrict government. And I often wonder how many actually understand that we deal with in this area. In fact, last year I was often frustrated and made this statement when we were dealing with the eminent domain. The term the government's right to eminent domain was used, and in my opinion, I think our founding fathers' opinion, that government doesn't have rights, only the citizens have rights. The government has authority, of which the Constitution checks. But I did want to say I was refreshing, and actually your whole testimony is restoring some faith to me, in that we do have some folks that are looking out for the interest of not just government but our citizens in positions such as yours. My concern goes back to the open records, which I am an open government advocate, but at the same time, sometimes government can be so open that your military plans or your strategic intelligence assessment makes the front page of the paper, which I think there are compelling instances that we do keep certain information secret, especially when it deals with our military plans and our security. When you mentioned the lack of biometric protection under the Open Records Act, the scenario I'm thinking is, instead of picking on the sheriff's department here, or it could be sheriffs, but now with the vulnerability we have with our water system, local government could determine we need to do a background check and fingerprint a new employee that we're bringing in to work in the water treatment plant. Is what you're saying is, as a resident of Massachusetts, I could ask for Bartow County to provide me the fingerprint card of all the employees in the water department?
to the extent that those fingerprint cards are maintained by the Water Department and not sent off somewhere else. If they are sitting around in a box in Bartow County Water Department, then I have 3 days to let you know when and where you can come and inspect those documents, or else we can arrange something else for your copying.
Thank you, I think. I appreciate you answering that question. But it seems like at some point we have in our open records quest, there's a crossroads here to where our open records have gone to the point to violate someone's right to security and privacy, i.e. mine. I'm thinking, I can't remember what it was I did recently, but I think it was renting a boat or something I did with my family. I gave, part of the agreement was, I think it was my car keys or my driver's license that I had to give to the attendant there. And they held that while I rented the boat. And that was their security that, when I returned the boat in good condition, I would get my property back. I entered into that contractual agreement willingly with a reasonable expectation that they would protect my property while they held it, and when I completed my end of the contractual obligation, returned the equipment in good condition, then I got my property back. I think there's a reasonable expectation that they are going to protect that. I think the employee has a reasonable expectation that the government will also protect their information while it is being on loan or whatever. And it seems like maybe we have a situation here to where our Open Records Act has failed to protect the individual's right to privacy as well. Is my assumption correct?
I would say you're pretty much on point. Now, I will add for clarity, there is one minor provision of the Open Records Act that says, to the extent that a person has an individual claim for an invasion of privacy under the Open Records Act, then it is incumbent upon that individual to assert that claim. The government can't assert that claim on their behalf. And so in situations where we have faced a challenging open records request that we do believe implicates an employee's personal right to privacy, what most county attorneys would do is contact that employee, explain to them the rights that they have available, and put them on notice. And then it is, unfortunately, incumbent upon that employee to assert that right personally. And now, I've heard from the other side of this issue that, you understand that when you assume public employment, it's different than private employment. You are a servant of the people. You're a civil servant. And we have the right to know things about you that we might not otherwise have the right to know about somebody who works for Bank of America or Wachovia. One of the things that for me personally, and it took some adjustment, but I've worked for the government for a long time, so I'm well adjusted at this point. But things like knowing my salary, knowing everything about every kind of personnel infraction I've had, not knowing whether or not I've fraudulently misused funds, but how many times I've been late for work, knowing whether or not any number of things that can be contained in a personnel file, beyond those essential things that you would think you see in anybody's personnel record. And once again, if someone requests my personnel file, short of the specifically excluded information, I have to assert my personal rights to protect any of that. And certainly, I may be successful in doing that, but I'm going to have to bear the burden to do it, and it's because I'm a public employee. And once again, there are those who believe that you chose to work for the government, and that brings with it a responsibility that we get to know everything about you. And once again, that's a policy decision that's been made at some point in time and rests with this body.
Are there any other questions of the committee? I've got a question or two for Mr. Kimbrough. Brooks, Jim Cooper. I am particularly attuned to government employment, particularly certain privacy measures regarding conditions of employment. I ask questions, moving forward, and this deals on the private employment side. And again, in the context of a right to work state and private industry, would it be inappropriate for a corporation to require one of their corporate officers, if you're going to be a corporate officer in this company, I'm going to put a chip in you because you've got information, you've got a signature block for this company. I want to make sure I can watch where you're going. I've got this little computer program that we're going to make sure we know where you are at all times because, by gosh, you're an officer of this company and millions of dollars are in your hands. We want to make sure you're not engaged in high-risk behavior. I've got questions. Is that appropriate, even in the context of a right-to-work state and private commerce? Or so I ask that as a preface to saying, in a government context, would it be within a chief of police's or a law enforcement agency's purview to say, you know what, we're going to put chips inside of all of our officers. Sometimes they're under deep cover, having a little tracking device in his wallet may not be good enough. By George, we think it makes sense. Again, some might giggle at that as, oh, that's fantastic. That's not going to happen. But really, as we look at this holistically for government employment, and government employment does tend to have those high-risk, special kinds of jobs that don't tend to exist in the private sector, like law enforcement, certain roles. Are there any limitations to that today, or would the legislature need to enumerate what is allowable, what's not allowable in the context of certain conditions on public employment? If you're going to be in my agency, by George, we're going to track you because you're a agent of the public trust.
I think that probably in both scenarios that you presented, the employer would lose, and for different reasons. I think that in the private setting, because there's not really any balancing to be done there. That would be a claim on that person's personal right to privacy, and I think that because of the way our government is set up and the way our laws are established, that personal right of privacy pretty much trumps anything that the business place could bring forward. There's not a legitimate business interest that I think could trump a personal privacy right in that context.
And I'm not arguing with you. I do respect your opinion in labor law more than certainly anyone else that we've spoken to today. I really think you've got a grasp of a lot of this. And where is the dividing line? To join my the company I work for full time, you do have to submit to a drug screen. You don't have to submit to recurring drug screens, but as an entry requirement to join the company, you have to do that. If I were a project manager for the state of Georgia, I wouldn't have to, but for MacTech you do. So there is a sense of which it's established through case law or statute somewhere that's okay. Mm-hmm. But I'm hearing you say, for MacTech, say, Ed, you're an officer of the company now. As soon as you make VP, we're going to put this. That sounds fantastic. You're saying that's crossed some line. Where is that line, and what's that based on?
I think that probably the additional protection you would have there, in addition to your personal right to privacy, is and I'm trying to figure out. Of course, you would have to assert this claim in a certain way, but I think that you could certainly make claims for intentional infliction of emotional distress, because that conduct is measured and is adjudicated by what sort of. Does this shock the conscience? Okay, and that's a phrase, but it carries significant meaning in the case law. And shocking the conscience, I think that while 50 years from now, 100 years from now, it may not shock the conscience to have a chip implanted in you. I think right now we're still there, where that idea is so ridiculous on its face that it bears no merit within the marketplace of ideas. There's no reasonable person seated on a jury who would not find that offensive. And for those same reasons now, once again, recognizing that the private sector is more free to engage in this sort of conduct than a governmental employer, absent a compelling governmental interest to do so, I don't believe that there is any way that the government could force an employee to have a chip implanted in his or her neck. And certainly, here at the local level, and I would dare say even to the state level, we don't have anything that is so vital and secure. And we don't have nuclear weapons in the state defense arsenal. We don't have nerve agents in the state defense arsenal. And that's the kind of compelling governmental interest that I think that you'd have to have before a reasonable person would not have that pushback, would not see that the government does not have a need to know that sort of detailed information about you. Background check, yes. 2 or 3 different security measures to allow you access to the facility, yes. But to know where you are at all points in time by means of a device invasively planted in your body, we're at a level where I don't think I can find 12 people in the United States to sit on a jury and say, well, that's fine. And that's just, that's assuming I could even get it to a jury. I'm not so sure that I could find a judge in the United States who would not throw that out on summary judgment and say this is just absolutely ridiculous.
So where do you sense in public employment that we draw the line from? I mean, is there any way we can put a box around? I mean, if we need to look at what's appropriate, what's not appropriate for public employment, I don't know that we have to do this, but I'm just, I want to, again, the vision of this committee was to be out ahead of common practice, to make sure if there's things we need to put boxes around in the law so that as folks get used to being scanned and chipped and things through commercial transactions, that 20 years from now we don't find ourselves in a weird place. I just want to, again, not to drag this on, but maybe it's a discussion we need to have offline, but I think it's within the purview of this committee to say what's appropriate, what's not appropriate, and make sure that that's sectioned off so we don't drift there and get there.
Sure. I would dare say that I think we have appropriate protections in place for what is appropriate and not appropriate in terms of the practice itself. I think that our one biggest threat is how we maintain and secure records in the public employment setting, where we have different standards about what we have to give up to anybody who requests the information. I really do see that as the primary threat area, because even as we look towards, once again, governments attempting to act like businesses, attempting to avail ourselves of what are recognized, accepted business practices, we bear liability there. That data may fall into the wrong hands, and there's nothing we can do about it. There's no claim that we can assert, and there's no standing that we have to segregate that material as it stands now. I believe that it's probably a relatively simple fix. Of course, once we define what biometrics are, I think it's a relatively simple fix. But that's our one outstanding threat area, is that we would like to be able to protect that information, and we'd like to be able to use it and be more efficient, but we've got to find that balance. We've got to protect that information when it's appropriate.
Yeah, I've got one more question that came up out of what you were just talking about, or what we were having a discussion about the school district and taking the fingerprint. Is there an intersection between open records and FERPA here, or is FERPA going to protect the public school students' records or biometric data, or do we have the same issue there?
Well, FERPA falls within that catch-all that there's a provision in the Open Records Act that says that any information that has to be protected by a federal law is also protected herein. So FERPA certainly applies in that area. The one question that I would have there, and it's merely a question, I'm not familiar with FERPA other than general familiarity, is I would hope that the definitions of record information is comprehensive enough to incorporate biometrics, because if it is not, and that's the challenge in the law, is that as technology advances, we define terms and we define things that we want to protect or we want to govern, and then technology comes around and evades our definitions. And we see that in telecom law right now as well. I mean, we have all sorts of laws about exchange access facilities, and nobody knows where VoIP fits in exchange access facility. And that's just a real world example of how technology evades our definitions. So I would hope that FERPA has definitions of the records that are kept that incorporates biometrics, because otherwise that is something that would need to either be addressed federally or here in state law.
Jim, since you know FERPA front and back, do you know?
Well, of course, federal law trumps state law in this matter, but FERPA explicitly tells us what we can, so there's no gray area there. So if we're required to protect biometric reason, it's not included in the list of things we may disclose. So it's kind of reverse the very explicit what we may disclose versus accepting what we
Okay. Okay.
Mr. Kimber, I do have hopefully one last question. Access to public places. There's some precedents of access to public places where folks are being asked to give fingerprints before they enter a publicly accessible place. You could view that in the context of courthouses, public buildings, or even publicly accessible privately owned space, which would be, protected, that not a private club, but something that's publicly accessible, like a sports arena or something. Do you anticipate the county commissioners, and I know you can't speak for your association formally, do you anticipate resistance or concern from local governments if the General Assembly considered involving themselves, writing a statute specifying what kind of information can be collected as an access requirement to a public place? If the General Assembly was contemplating, you can't require the following things as a mandate before someone can have access to the courthouse, but the following things you may require.
I think that county commissioners would definitely want to be engaged in that discussion.
Sure.
I'm not sure that there would be true resistance. It would just be a concern because, once again, that speaks to our philosophical position about home rule.
Sure.
And our idea being that as the owners and maintainers of at least county properties, that it is within our constitutional, our local constitutional right to control and protect those properties, and do that in a way that makes sense for our communities. What makes sense in Fulton County does not necessarily make sense in Toombs County.
Mm-hmm.
So I think that the county commissioners would be concerned merely in that aspect only, but would certainly be willing to come to the table and provide input as to so how we can make legislation in that fashion flexible enough for everybody to deal with.
And to your home rule question, I tell constituents all the time back home when they ask about our role, the General Assembly establishes a playing field, and it's up to the cities and the counties within the confines of the boundaries of that playing field to fill in the gaps and establish the details. I think what I'm looking at is understanding the differences in Toombs County and Fulton County. That we not write law for Fulton County, we not write law for Toombs County, but we set a playing field that's certainly puts a box around what may be appropriate, certainly a broad box. Sure. And I know that would be a desire, but a box nonetheless may need to be considered.
Right. And in that vein, I don't think there will be any resistance. I don't think that would be a problem. I think that they would be willing to come to you and engage and help you draw that box appropriately.
Okay. Before we go to anyone else, anyone on the committee, another question, Mr. Kimbrough? Anyone from the audience would like to speak briefly? Ms. Garrett.
I just have one quick statement. At the ACLU, we're, of course, strong advocates of privacy rights and strong advocates of the Open Records Act. I'm not so sure that there's a big of a gap in the Open Records Act as has been presented. If you look at 50-18-72A2, and I have not looked this over, and so I haven't looked at any case law, but it does exempt from disclosure medical information, vet records, and similar files. So I think that there can be an argument made that some of these biometrics may fall in that. I'm not sure why the county government would be collecting biometrics. That might actually be the more troubling issue, is them collecting biometrics to begin with, but I'm not so sure that there's a gaping hole there. And again, I'll have to look into that, and I'll contact Howard Manheimer from the Georgia First Amendment Foundation, who knows these things frontwards and backwards. But I just wanted to present that. And if there is a hole, I think it can be easily filled by just inserting the word biometrics rather than completely rewriting the
and I think that if I might be allowed to respond to that, I think that Ms. Garrett and her cohorts would be the first ones asserting the argument that any exemptions to the Open Records Act must be construed as narrowly as possible, and you cannot expand the words of the Open Records Act to fit your purposes and your needs. So, I respect what she says, but I certainly see where that would be the first argument they would make to say, no, you've got to give me this data, because it is not expressly exempted from the Act, and that is a standard that our courts have set.
Super. Mr. Mr. Kimbrough, if there's no further questions, you have nothing else for the committee, I thank you for your
Thank you
time.
very much. Y'all have a wonderful evening.
I'd like to, in closing, I'd like to thank everyone for coming today. I think the camera's going to come back on and watch the closing of the committee. I will say the next formal meeting of this committee will be November 29th. That's going to be the closing meeting of this committee. I'll talk to the members about any discussions between now and then on subject matter. Any other questions from anyone in the audience regarding what we've discussed today? Hearing none, I'd like to hereby effectively close the meeting. Thank Ms. Nuremberg, our committee assistant, and MAG for sponsoring lunch today, Medical Association of Georgia. Folks, thank you for your time.